Good morning, everybody. You're all very welcome to this workshop today on the contribution of the UN War Crimes Commission to international criminal law. I'd like to begin by thanking, first of all, our keynote speakers who've travelled to be here today and others who have joined us here today and travelled, some from abroad as well as some more locally based. So thank you all for being here today, and of course those who are joining us online as well. I'd like to start by thanking our keynote speakers, who are, of course, Professor Dan Plesch from SOAS University in London. We have Dominika Uckiewicz from the Pilecki Institute in Warsaw, and we have Professor Andrew Williams from the University of Warwick in the UK as well. Thank you to the funders of the event, who are MUSI, so Maynooth University Social Sciences Institute, and the School of Law and Criminology here in Maynooth University. Thank you also to Anne Hamilton-Black of MUSI and to Stacey Campbell for their help in organising this event as well. So the purpose of the event today is to bring together UN War Crimes Commission experts and scholars to discuss how the institution has contributed to international criminal law, and ways that its influence has been acknowledged, and ways that its influence should be acknowledged as well. Last year marked 80 years since the creation of the Commission in London in 1943, October 1943. And to mark this occasion, as co-director of the Research Centre in International Justice in Maynooth University, I've organised this event to acknowledge that the creation and of the Commission and its seminal anniversary. So the UN War Crimes Commission was inaugurated on the 20th of October 1943 in the British Foreign Office by the representatives of a number of Allied states. It was unique in that it was the only post-war institution that focused on war crimes prosecutions on a national level rather than via an international criminal tribunal. It had the status of an international organisation and operated from 1943 to 1948. The Commission's main task was to investigate allegations of war crimes, to record evidence of the commission of war crimes, and to identify the perpetrators. During its lifetime, it created over 8,000 files representing some nearly 37,000 groups and individuals, not to mention the conclusion of 2,000 trials. One of its main purposes was to achieve post-war readiness, in the sense of being prepared to facilitate, to create files in order to allow for criminal prosecutions in tribunals after the war, something that was not achieved, of course, after the First World War. The trials were conducted around Europe and in the Far East before national and military courts and tribunals, and this all happened under the umbrella of the UN War Crimes Commission, of course. Significantly, some of its most important contributions in terms of to international criminal law as a wider discipline was its influence on definitions of crimes that were included within the Nuremberg Charter. Notwithstanding its achievements, its prominence continues to be overlooked by the International Military Tribunal at Nuremberg and the International Military Tribunal for the Far East in Tokyo. It has been described by one eminent scholar as the best kept secret in international criminal law. And since 2017, the archives of the UN War Crimes Commission have been made available to the public and are accessible online. However, analysis of the UN War Crimes Commission and its work and its contribution specifically to international criminal law remains often overlooked and underexplored. Although I do hope it's great to see such increasing scholarship in this area. I really do hope that that is changing. So a few housekeeping notes. Online attendees are welcome to share their comments and questions in the meeting chat. There's been a slight change to the programme. So the last panel 4 is no more. And we will conclude with panel 3, which will take place between 1 and quarter to 3 p.m. And we will finish up around 3 o'clock as well. So just to flag that with our online and in-person attendees. As you can see from our programme, we have a wide-ranging collection of very interesting contributions that we're going to discuss today, and I really look forward to those discussions. So some things we'll be talking about and looking at will be the UN War Crimes Commission as an early example of the principle of complementarity, the right to a fair trial in UN War Crimes Commission practice, and the legal treatment of the question of immunity in the work and trials of the UN War Crimes Commission, the position of victims in the trials, and we also have country-specific analysis regarding Ethiopia and Poland as well. So I do look forward to those contributions. So without further ado, it gives me great pleasure to introduce our keynote panel of speakers today. So our first keynote speaker is Professor Dan Plesch, who's Professor of Diplomacy and Strategy at SOAS University. Professor Plesch is one of the leading scholars on the UN War Crimes Commission. He's published widely on the topic. Professor Plesch has significant experience in navigating and researching the extensive UN War Crimes Commission archives, and he was instrumental in persuading the UN to release the archives to the public in 2017. In addition, he's one of the few academics that actually had access to the archives before that time. He's the author of many books, including Human Rights After Hitler, The Lost History of Prosecuting Axis War Crimes, and that book is specifically on the UN War Crimes Commission. So the title of Professor Plesch's keynote presentation today is Head of State Immunity in the Files of the UN War Crimes Commission, Implications for Bilateral Prosecutions Today. So Professor Plesch, or Dan, you have the floor.
That's kind. Shall I speak from here or do you want me to come up?
What would you prefer?
I'm happy to be here.
Yeah. Okay.
That's all right?
Yeah, look away.
Thank you. Okay. So with a little help from our tech support in a minute, we'll look at the number of images and sources. But just to say, it's a great pleasure to be here. And Amina, I do remember when you first came to visit me in London a few years ago to talk about joint work on this topic. That was very welcome, and your engagement and those of a number of other colleagues here today, I think, have given me great support and encouragement and intellectual vim and vigour to continue working on this project altogether. So thanks to you and to your colleagues and the funding provided to this event. So greetings everybody in the room and online. You ought to be perhaps more aware that if we can pull up that.
Just open the screen and I can share.
The Zoom? Yeah, yep.
You've got that first slide. If not, I can do without it. It's all coming help.
I think I need to close the windows in order.
Well, we can come to the internet stuff a little bit later, and I'll just press on and see how we get on. So, well-known public figure, Adolf Hitler, that's it. And if you click on it, you might make it larger. Good luck. If not, it's okay. We'll leave it there. That's fine. Adolf Hitler, as living head of state, was indicted for war crimes by several European states in the winter of 1944-45, with the support of a dozen other states, including China, France, the UK, and the USA. While these proceedings were conducted in secret, sealed files were, as now, quite common in legal practice. This fact was reported by the Associated Press in this fact was published in the history of the Commission in 1948. And at the time, in statements of that in the House of Commons, the British government confirmed that Hitler had been listed as a war criminal. Nevertheless, the general assumptions in international criminal law do not take notice of this fact. And if people are aware of it, perhaps they may think that this happened in a multilateral forum, analogous, better say, to the ICC and its indictments of head of states today, with, for example, President Putin from the ICC. But in fact, these were bilateral indictments. Now, I find it strange, as a historian, a simple historian, rather than an august lawyer, that the international legal community has not taken more cognizance of this fact. In 2017, I published an account of this in my book, Human Rights After Hitler, and the Associated Press, which I think Mark Twain referred to as an organization close to the voice of God, as a global authority. Associated Press ran a story on my book headlined, "Hitler was indicted war criminal at death." Now, I hope on that occurrence that there will be a queue of international criminal lawyers banging on my door wanting to know more, but sadly, no. However, today, the issue is rather more at the forefront of public discourse. Notwithstanding events in Ukraine and Gaza, the issue of prosecution of heads of state and government and foreign ministers is also live, with the French government's indictment of Syrian President Assad and by a group in Switzerland of the Israeli President Herzog. For some commentators, these charges have no standing, given the 2002 decision of the International Court of Justice in what is known as the arrest warrant case, that there is no customary international law supporting the liability of heads of the state and government and foreign ministers against indictments by other states outside the direct jurisdiction of the International Criminal Court and like bodies. But for others, these indictments are welcome and valid. The long overlooked customary international criminal law from the 1940s that I'm discussing here can be seen as contradicting the ICJ judgment and reinforcing the validity of the Assad and Herzog cases, and to have relevance elsewhere with respect to Ukraine and Gaza. For the now unsealed documentary record provides individual and multilateral state practice from the 1940s that set the immunities of heads of state and government and foreign ministers aside in a decision of the United Nations War Crimes Commission and subsequent actions of that body and its member states. I'm pleased to say that last November, ICC Judge Joanna Corner drew attention to the listing of the then German head of state and government, Adolf Hitler, in my book, and that he was subject to numerous war crimes charges in 1944 and 45, supported by the United Nations War Crimes Commission. And in the paper, which I'll put on your website, there's a link to her remarks on this. Now, in specific reference to Adolf Hitler, this graphic, which you can see on the screen, hopefully, it's one of thousands and thousands of UN War Crimes Commission indictments, what are known to the cognoscenti as the charge files. And when I first came across the first of these early in my research, it made me realize that this was a serious bureaucracy in, let us say, the high analog era. There is a pro forma charge, serial numbers, dates of receipt in the Secretariat, which country is charging which other country, what are the serial numbers of the charges, who is being accused, and further down the pro forma, there are details required of what law has been violated under domestic or international law, other details of the facts, and indeed what is the likely course of defence. And this was a standard form that states had to fill in when they brought their charges to the Commission to seek the advisory opinion of the Commission that there was a case to answer. And by the way, this integration of evidence collection and pre-trial affirmation is, I think, is something which very well could be used in Ukraine and elsewhere, because at present, and I digress slightly from my topic, at present, all the evidence collection processes, Human Rights Council and so on, have no pre-trial element. And they would be greatly advanced if the pre-trial element was included, not least because that pre-trial process, you can imagine, producing a further decade of legal analysis if it isn't done, hasn't been done at the outset, and the witness statements and so on become less reliable with time. So having the evidence collection stand alone, which is present practice, is retrograde compared to the practice of the time, which integrated evidence collection promptly with a pre-trial process, which colloquially one might call as meeting a prima facie standard in the continental system, that of a magistrate's court and so on. So returning to the focus of my presentation today, the UNWCC documents include legal submissions by member states, Commission minutes and papers, and correspondence between the Commission, the Allies, and indeed the peace treaty between Italy and the Allies in 1947. In late 1944, after some debate, the Commission adopted the rule discarding as irrelevant the doctrines of immunities of heads of state and government and acts of state. This decision, describing the Commission's history, was published by the British in 1948, but given scant attention since. The UNWCC decision was made by 16 member states after investigation by a subcommittee led by Lord Wright of Durley, a former senior English judge. The Commission itself was chaired by Sir Cecil Hurst, a member and former president of the Permanent International Court at The Hague, and who had been British representative at the Hague Convention of 1907. So these individuals presiding over this process were the most senior legal figures of the time. This is not some NGO gathering, some ad hoc vindictive group. The states concerned made sure that their representatives considering these matters were the most senior legal figures of the era. And his colleagues, René Cassin, André Gros from France, for example, were of similar eminence. This decision constitutes substantial customary international criminal law, consisting of the advisory opinion of the UNWCC and the opinion juries of its member states, and the judges and experts that represented them. Adolf Hitler and his senior officials were then indicted by Czechoslovakia, Poland, and Belgium as member states of the Commission. The Commission considered and approved the charges as meeting a prima facie standard, and then Hitler and his officials were listed by the Commission as accused war criminals. Now, at this point, in the winter of 1944-45, the UNWC was operating a system of domestic jurisdiction with international support, and this was the only institutionalized international legal response to Nazi crimes envisaged by the St. James Declaration of 1942 and the Moscow Statement on Atrocities of 1943. The London Declaration, the London Charter, was a distant dream at this point. That Hitler died and his foreign minister von Ribbentrop was condemned at Nuremberg do not negate the authority of these indictments, holding the individuals liable for crimes while they were still in office. In addition, and perhaps arguably of lower status, and I won't discuss them in detail here, a number of continental states prosecuted Hitler's Gauleiters, his provincial heads of state, as governors of the occupied and dismembered territories of the Reich. Arguably, these individuals also can be considered as heads of state. Certainly, they were regarded as such by the poor folk they governed. And it's also, this is being covered by a colleague, there's also the issue of the Italian leadership eventually being indicted by Ethiopia with the support of the Commission following the peace treaty with Italy in 1947. Very briefly, the Czech indictments, which begin with the cautious, one might say, legal position that the Nazis imposed a new legal system in Czechoslovakia, and that itself was a violation of international law, was the first charge brought by Czechoslovakia, and then afterwards another 10 or so indictments amounting to thousands of pages of evidence were brought forward concerning better known occurrences, Lidice, Buchenwald, and Dachau. Poland's focus was on, quote unquote, the biological extermination of the Jews in Poland in violation of the Hague Convention of 1907. And Belgium followed suit in the spring of 45 with charges concerning Auschwitz and Buchenwald. Now, returning to the contemporary arena, these decisions and these indictments directly contradict the position of the International Court of Justice in 2002. And if you read the arrest warrant judgment of 2002, it makes absolutely no reference to these decisions and the work of UNWCC. And talking to the folk around the court, some former judges, those involved in the process, Belgian lawyers who were engaged in that process, they had no awareness whatever of the UNWCC. Now, a little bitter and caustic here, but I think they simply didn't do their homework properly. They didn't do the literature review, to put it crudely. The court staff failed in their responsibilities. Presumably, the history of the Commission is available in the International Court of Justice. Presumably, Sir Cecil Hurst, former president of the Permanent National Court, has some name recognition, but nevertheless, they passed over the work of the Commission. Now, understandably, at the time, the detailed documents weren't there, but the fact of the decision, its footnotes and references to the body of the Commission should have been enough to make the ICJ and the lawyers engaged research the topic. They didn't, but as in any legal process, it should be open to new facts. Now, some of the world's leading international criminal law bloggers, blog sites have rejected material on the grounds that it hadn't already been considered by the International Law Commission. I sent them a submission, or by the International Court of Justice, which is rather like an appeal court refusing to take new evidence because it's new evidence. And I find it extraordinary, the caution and conservatism, and dare I say, intellectual cowardice of leaders in international law academia in not taking this issue on more forthrightly. So with that provocative, challenging and subversive comment, I'll bring my remarks to a close. But we could also at some point, I can show you on the website, you are welcome to yourself download and analyze the 2,000 pages in the bundle of documents that were considered by the UN War Crimes Commission with respect to Mr. Hitler. Thank you.
Thank you very much, Dan, for that really informative and interesting presentation, and for sharing in particular your personal feelings towards the really the overlooking of the UN War Crimes Commission as a source, as a valuable and rich source of law, of customary international law, and how that resonates in contemporary international criminal law. I think it's a good way to start the tone for the day as well. So thank you for that. So our next keynote presenter is Professor Andrew Williams, who is head of the School of Law in the University of Warwick. So Andrew is an eminent scholar and a lawyer on the topic of legal history, including UN War Crimes Commission. He's the author of A Very British Killing, The Death of Baha Musa, published in 2013, which won the George Orwell Prize for Political Writing. His book from 2016, A Passing Fury, Searching for Justice at the End of World War II, examines British investigations and trials of Nazi war criminals after 1945, and it was shortlisted for the 2017 CWA Daggers Non-Fiction Award. In addition to that, he's the founder and co-director of the Centre for Human Rights in Practice, which undertakes human rights projects nationally and internationally, whilst also providing students with the experience of human rights related work. So the title of Professor Williams's lecture today is The Myth of Fair Trial in International Criminal Justice. So Andrew, you have the floor.
Thank you very much, and thanks to Amina again for the invitation. Echo Dan's words about the sort of development of this grouping, really, of people, scholars coming together, which is so important, really, to look back into the history of international criminal justice. And I think Dan's been at the forefront of that for many years, almost a lone voice in terms of trying to bring that archive and recognise the importance of looking at the archives to understand justice today, international criminal justice today. We have to understand the injustices of the past, and I'm fully in tune with that direction. It's a fantastic job that Dan has done over many years. So we need to pay tribute to that. I guess I'm going to introduce a sort of critical voice in the sense that undoubtedly the evaluation of the archives will unpick some aspects of the justice scheme that was developed in the 1940s and post-1945, which perhaps cause us pause to think about how international criminal justice has developed since. So what I'm going to do is just trying to sketch out what is a concern based on looking not just at the UNWCC archive, but also the national archives of criminal trials that were brought by, in my case, the British authorities in Germany post 1945 to 1948, and to see whether actually the construction of international criminal law is problematic in terms of its adherence and use of fair trial as the foundations of the scheme of justice that we supposedly have today. And here I do worry with Dan about the predominance of lawyers determining how to look back as well as how to look at today's problems. I think there is a development of a juridification of justice, which may sound like a sort of tautology, but actually it indicates the nature of lawyers within a closed system, not really being conscious of both the past in terms of how ICL has developed, but also the present and how to solve problems of justice today. So the argument really is looking at the fair trial, as I say, is the foundation of international criminal justice, just to ask the question of whether our understanding of fair trial really should be the cornerstone. That may be provocative as well, because everything we think about justice is associated with fairness. And if we are going to have processes of criminal justice, that entails supposedly trials, and those trials should be fair. But there are certain questions about the nature of fairness, I think, which need to be teased out. And perhaps looking at the archives, looking more carefully at what actually transpired post-1945 is something that really, I think, is a project that has been failed within the legal community and hasn't been addressed. I think, as Dan rightly says, it's been ignored for the large part, not taken seriously. So I'll try and outline the propositions that sort of try to, and I've got 5, hopefully I'll get through, which relate to this unteasing of the nature of fair trial within international criminal justice. So the first point, I suppose, first proposition is that the roots of adherence to fair trial were not based, as some might like to infer today, on human rights norms, but on a peculiar model that was fixed at the end of World War II, predominantly by Robert Jackson, with a very short timescale, thinking about the design of practically enforcing all the sense of justice that was based on the kind of accumulated information and evidence that the United Nations War Crimes Commission had put together. And his rather hastily conceived idea was pretty much political as well as legal. And it was this idea that it was going to be comprehensive justice rather than representative justice. So the intention was to prosecute everyone. That was the stated idea, who had committed a crime of war. Personal responsibility on all perpetrators, top to bottom, everybody. Not just in terms of crimes against humanity, which was the developing idea that awful crimes have been committed against civilian populations, against combatants, the whole sense of the aggressive war. It was everything, including war crimes, which were the basis of sense of crimes in war in any case. And the means of doing so was by individual criminal trials. That's what happens when you're comprehensive. You don't collect, you individualize. And they were supposed to be dispassionate hearings, as Jackson said, which were recognizable as reasonably fair. So in other words, it wasn't a human rights based idea. It was rather a sense of what would be reasonable in the circumstances. And that has its consequences, I think, because in terms of why it was seen as reasonably fair was very often, I think, in some of the UNWCC literature, I think about SOAS, is that it was a counterpoint to Nazi criminal justice. The idea that one had to show where the whole system of law within the Nazi regime was abhorrent. And in order to do that, one had to show the counterpoint of that, or at least not replicate it in terms of the justice scheme post-World War II. It was always also based on the idea that there was a binary outcome, guilty or innocent. There was no opportunity to consider scale of guilt or to unpick the philosophical sense of what guilty may mean, what responsibility may mean, what accountability should mean within the post-war era. It became very much a legalistic either-or situation. And I think that in itself caused considerable problems for those undertaking the schemes of justice post-1945. It was, however, recognised that there was a distinction to be made organisationally and politically between major war criminals and minor war criminals. The very nature of this binary itself was problematic and recognised by many practitioners straight away in terms of the difference between the Nuremberg trial and the concentration camp trials, for instance, where the idea that one was minor, one was major, may be a matter of language, but nonetheless communicated some sense, I think, of distinction that wasn't warranted. In other words, the scale of criminal endeavour was equivalent, or at least there wasn't a reason to distinguish between those abhorrent crimes, either crime of war or crime against humanity as an institutionalized Nazi regime, and also the application of that philosophy through concentration camp, genocide, etc. So there's a sense there, I think, that the construction of it was very peculiar and very particular to the circumstances that wasn't necessarily then going to be played out effectively. Which brings me to the second point, which was we've paid too little attention to the minor war crime trials, I think, in the sense that this is where the bulk of criminal justice was done. Nuremberg was effectively a show trial. That was its purpose in the classic sense, not in the Soviet sense or even the Nazi sense. Those trials across Europe, however, were undertaken by various nations, stepped into the show trial arena, but out of public view. So if one looks at the archives of the trials themselves, you can see they were pretty much behind closed doors, other than one or two, Bergen-Belsen trial, for instance, which was filmed. But otherwise, they were conducted out of public view. Public were allowed in, but the interest in it soon waned post-1945 to the extent that it was hardly reported at all. So there's an understanding that the whole sense of criminal justice as a public endeavour, as an international global attempt to show what was wrong and how the wrongdoing was constructed through the form of a dispassionate hearing, was pretty much lost and left to the archives rather than public documentation. Something that I think that was echoed through the UNWCC restriction of its archives for many, many years. There was also, when we look at those minor war trials, we suddenly realise the flaws in the system and the impossibility of the model of justice proposed. The idea that comprehensive justice was a reality, could be realised, was broken almost immediately. And there also shows that there was an absence of a fair criminal justice system. Now, our notion of fair trial, as it's developed post-1945, is certainly based on the idea that we operate within a fair criminal justice system, and that the fair trial is a product of fair investigation, of fair identification of perpetrator, of inclusion of victims, and notion of some kind of cathartic healing within a society. All of these attributes of fair trial are lost within the system when they're taken out of a society and just seen as an individual operation in its own right. At least that's the sense of international criminal justice hasn't really grappled with that idea that a fair international criminal justice system has yet to be constructed. Also, the close reading of the source records, I think, when we open up those archives and really look at them, and I don't think we've done enough in terms of comparative assessment of the trials, we show that there were very different attitudes towards what was fair and what wasn't. So the approach in Bergen-Belsen, for instance, was very different from the trial in Dachau, run by the Americans. In Bergen-Belsen, the British were very much testing the waters, but it was based on an idea that sort of strict rules of evidence applied to on the British model. The Americans were much more keen on crimes of association. In effect, if you established that you're a member of the concentration camp system, that was sufficient to condemn you as a participant. And that certainly carried forward slightly, but with that caveat of the British idea, which is you need individual evidence to show particular violence undertaken and complicity in a violent, atrocious act. So that's something that I think has never really been analysed sufficiently to say, well, what kind of scheme of justice are we looking at? Is it associative with a system of atrocity? Or is it individual that you have to look at atrocious acts one by one? So I think we've not looked properly at that history of flawed concept as it was played out. And this, I think, has consequences for today. In effect, the process of this movement towards individualized trial has allowed the ability of certain states, and the UK is a particular concern, so that it can process it not on the basis of systemic wrongs, but on the basis of individualized wrongs. And this raises the particular issues of UK cases of allegations of atrocious acts in Iraq and Afghanistan. We're talking last night about the Afghanistan inquiry, which many people aren't aware of beyond a very limited audience, which at the moment is going on in London, which is inquiring into the behaviour of the Special Air Service troops in Afghanistan between 2010 and 2012, very limited period, where they operated death squads, in effect, killing civilians without any due purpose. And this is the allegation, that there was a process of killing that was undertaken as a rite of passage of the members of certain units of the SAS. Since 2012, those allegations have been known, but have not been investigated properly by the Ministry of Defence, have not resulted in any effective means of inquiry, hence the need that was established only last year into investigate it through a public inquiry. But if you look at the way the public inquiry has been operated, supposedly within a fair process, it only looks at the individual actions that are going to be undertaken. And in that, it is consistently being prevented from doing so by reason of lack of cooperation from the government, lack of cooperation specifically from the Ministry of Defence. Now, that's an internal process that the principle of complementarity accepts and allows. There is no intrusion there from an international criminal justice system. So that, I think, shows us that the problems of the individualization of justice, which is predominantly the underpinning of our notions of fair trial, has its roots in that 1945 understanding, but has led to a failure really to address the very peculiar circumstances that crimes of war are committed, within which crimes of war are committed. And that means that there is a sense of, is the structured system actually fit for purpose? That's an open question, and I think it's something that we can debate. My time is up. Thank you.
Thank you very much, Andrew, for that excellent keynote presentation. So our next and final keynote presentation is from Dr. Dominika Uckiewicz, who is who's an assistant professor at the Center for Totalitarian Studies at the Pilecki Institute in Warsaw in Poland. Dominika is a lawyer and a historian. Her research interests lie in the field of transitional justice, legal history, and specifically during Polish relations, with a particular focus on the history of international criminal law and the war crimes trials after the Second World War. And Dr. Uckiewicz is also in the process of publishing a book, particularly on Polish policy towards the prosecution of war crimes during the Second World War and the aftermath of the Second World War as well. So we do really look forward to that book. So Dr. Uckiewicz's lecture today is entitled "Focus on the Vulnerable: The Victim-Centered Approach in the Works of the UN War Crimes Commission." So you're very welcome, Dr. Uckiewicz.
Thank you very much, Dr. Adanan, for the invitation and to the School of Law and Criminology at the Maynooth University for hosting this event, and Amina for inviting me to have this keynote lecture among our great colleagues. How do I navigate? Okay. In my presentation, I would like to focus on the UNWCC, or present the UNWCC as an institution that strongly supported a victim-centered approach in its works and in the investigations and prosecutions of international crimes conducted by Commission and Commission's member states. I will also show a few examples from the Commission's case law, presenting the vulnerable victims, also some examples of gender-based crimes, how they're reported, addressed in Commission's work. When asking about the origins of this victim-centered attempt or approach in Commission's work, we need to go back to the outbreak of war and the first months and years, even before the UNWCC was created, and to the activities and strong involvement and engagement of the representatives of victim states occupied by the Third Reich and their governments in exile, that were the driving force behind the establishment of the UNWCC, and before that, behind developing a common war crimes policy of allied states. Already in 1940, the Polish and Czechoslovak governments in exile undertook the initiative to develop these principles of dealing with crimes committed in occupied countries. In November 1940, they issued a common resolution protesting against the mass atrocities against civilians, destruction of cultural heritage, persecution of intellectuals in Nazi-occupied countries. The race for these initiatives were the victims' accounts, reports, but also demands that was communicated to the political representatives in exile to bring the perpetrators to justice, but also to expose the sufferings of civilians, of persecuted groups in occupied territories. So this focus on victims and sensitivity towards their needs and expectations is rooted in these early initiatives on accountability that were also mirrored in the works of London International Assembly, Cambridge Commission on Penal Reconstruction and Development that were created in 1941, assembling lawyers and experts in international law dealing with questions of accountability, new types of criminality, including the persecution on based on ethnic political basis. And on this ground was further developed the notion of crimes against humanity. In 1941, Polish and Czechoslovak lawyers drafted the guidelines of common war crimes policy of allied countries that include the documentation of war crimes, compelling list of alleged perpetrators, and call for establishment of international criminal jurisdiction. And these principles were accepted and adopted in the Declaration of St. James's Palace of January 1942. It was the first official statement of Allied countries which placed the punishment of war criminals among the major war aims. But it was also devoted to the documentation and capturing the experience of witnesses of occupied territories. In summer 1943, declarations, member states, parties to the declaration have established the Inter-Allied Commission on the Punishment of War Crimes, which was responsible for documenting German crimes and conducting international information campaign that was presenting victims and witnesses accounts from the occupied territories from around the Europe. I choose here a few publications focusing on the vulnerable victims or with a focus on particular groups as women, in case of Lewice, also children or Jewish people who were also the first targeted group, and also can be scored to this group of vulnerable victims because of the grounds of the persecution the Jewish population has suffered. The efforts to punish the perpetrators, but also focus on the rights and experiences of victims, were also present in instruments of national law, not only in the works of UNWCC. As example, we can quote the Polish war crimes legislation from spring 1943 that was establishing the individual liability for international crimes in an act of internal penal law, and was exposing the new types and legal definitions that required new legislation. And while processing this project, this penal law instrument, the problem of extermination of ethnic, political, and cultural groups, expulsions, of course, annihilations of minorities of Jewish population, but also gender-based crimes as forced prostitution or rape were discussed and were presented as examples demanding justice and accountability structures on national level by implementing this type of legislation, but also international cooperation that was enacted in autumn 1933 when the UNWCC was created. How has the UNWCC enforced a victim-centered approach? I would like to focus on two aspects: on the documentation of war crimes and discussions on legal definitions and principles. The Commission was responsible for the pre-trial validation of the documentation of international crimes. It administrated relevant data, compiled list of alleged criminals, and supported Allied countries in conducting investigations, but the Commission itself possessed no investigative powers or machinery. All activities that were related to fact-finding were conducted by the Allied governments and their special war crimes offices. Some refugee governments documented their crimes committed in their countries and adjusted this structure to UNWCC requirements in 1943, but others expected detailed guidelines in that field. And Commission's role as the central agency coordinating these works was essential for developing international cooperation aiming at bringing war criminals to justice. This operative framework focused not only on the demands of retributive justice to identify the perpetrators and establish the facts essential for attribution of guilt and conviction, but it also implemented a victim-oriented approach. UNWCC compared lists of war criminals, which were the basis of the Central Registry of War Criminals and Security Suspects, but at the same time, the Commission compiled lists of witnesses and prepared special instructions for member countries and their investigative teams on interrogating victims and witnesses. The Commission has also obtained evidence from refugees and displaced persons in the care in the United Nations Relief and Rehabilitation Administration. Investigators cooperating with the Commission and national offices succeeded in establishing facts and data on thousands of crimes committed during the Second World War, and in many cases, very specific details of particular offenses. These details included numbers of victims, types of suffered harm, or personal data of victims and witnesses to the crimes. In cases submitted to the Commission during the war, so before summer 1945, there was this practice of anonymizing the data of witnesses and not to expose them or their family members living in occupied areas to persecution. And in present day's terms, we could classify this practice as witness protective measures, anonymization of their identity and personal data. Also, the discussions on principles of individual liability for international crimes is a proof of the great sensitivity of Commission's members to the experience of victims of organized crimes committed in occupied territories. Commission's members have contributed to the debates on definitions of war crimes, crime of aggression, and crime against humanity. With the proposal to recognize crimes against humanity, Commission's members aimed at securing international legal protection to civilians experiencing organized violence, including the citizens of Axis countries, exposed to persecution and extermination by their own state. Mainly, it was supposed to protect German and Austrian Jews. In summer 1944, the Commission sought approval from British government to extend its authority to crimes against humanity and to collect evidence on racially, politically, or religiously motivated crimes committed also on enemy nationals, not only on Allied nationals. This didn't succeed. Therefore, Commission's mandate was limited to investigating war crimes committed against Allied nationals. Nevertheless, already in the first cases reported to the Commission, we can find the elements of the definition of crimes against humanity. Different types of persecution, grounds, and techniques of annihilation were discussed in these cases. The systemic violence targeting the most vulnerable victims and persecution based on ethnic, political, and cultural grounds was discussed and analyzed. The case that has already been mentioned by Dan Plesch today concerning the legal persecution, discrimination of Jewish population in Poland is a very good example of discovering new layers or levels of criminality. This chart was addressing legitimization of Nazi violence in the legal order that was aiming at annihilating, distracting Jewish population. But when we go into details of this case description, we can also discover very important element of the crimes of persecution of identity of a persecuted group, and similar cases were also constructed to highlight this organized systematic crime against Polish population. As Dan mentioned, similar cases were also submitted by Czechoslovak government. Persecution against Jews was mostly presented and reported in crimes concerning concentration camps and deportation to concentration camps. And the legal qualifications of these cases was mostly murder and massacres, torture of civilians, deportation of civilians, treatment of civilians under inhuman conditions, as we see in this chart concerning Auschwitz concentration camp from 1944. when we go deeper into analyzing these cases of complex crimes, including different types of violence, we can also find descriptions and elements of, as you can see here in these two codes, gender-based violence. I choose two quotes, very short fragments from the Auschwitz charges, which are very extensive documents against, in the first case, over 90 defendants, and in the second case, almost 40 perpetrators. On the margins of these case descriptions, we can also find very important details on different underreported, unknown, or crimes as rape, sexual abuse, or killing pregnant women who became pregnant after having been raped by a concentration camp guard. When it comes to examples of crimes against women or gender-based violence from the UNWCC case law, we can identify many crimes, types of violence, some of them as parts of very complex cases, as just presented. Here on the screen you can see, I believe, the first case reported by France in February 1944 concerning crimes in the Drancy concentration camp, which also include the charge of enforced prostitution of young girls, among other violations. There were also many, or I believe, not singular cases devoted to individual cases, acts of rape or forced prostitution, reported mostly by French, Belgian, but also Dutch governments. What is important, these individual cases, focusing on particularly these types of crimes were reported after 1946. And maybe on my last slide, I will also only show a few examples of crimes against children that can be identified, and in the UNWCC cases, crimes of deportation and denationalization concerning kidnapping of children from occupied territories, their Germanization, with very contemporary relevance, but also mass murder, ill treatment, sexual abuse of a minor, abduction for prostitution, also forced labor, starvation, being subjected to medical experiments. With these few examples, I wanted to draw your attention to extensive case law concerning the vulnerable victims, the question of vulnerability in works of UNWCC, and maybe to open up a discussion on models or elements of retributive justice, which we can find in works of commissioned next to the retributive justice and attempts or initiatives on accountability, which we are discussing today. Thank you very much for your attention.
Thank you very much, Dominika, for that really insightful overview of some of the crimes that were prosecuted under the UN War Crimes Commission umbrella. Particularly interesting to see some of the specific crimes that you listed, especially those that relate to gender-based violence, which is often viewed as being quite, wouldn't say recent, but it's often, in terms of its prosecution at international criminal tribunal level, you know, that it's viewed as quite a recent phenomenon under that umbrella. But really interesting to see that there is this body of trials and cases that were prosecuting those sort of events as well for the 1990s. So thank you for that. So now I'm going to open up the discussion to both our panel and to those of you joining online and those of you here in the room. I'm sure some people have some questions that they would like to ask the Keynote panel. In addition to that, the Keynote panel members might also have some questions or issues that they want to follow up with their fellow speakers. So I'm going to sit over here now, and we might just open up the floor for discussion. We have about 25 minutes, just in an effort to get back on track with our schedule. And so, Andrew, do you have a
I have
question?
a question, yes. I'm the privilege of being up at the front. Dominika, I think an excellent presentation. I think it's been a sort of narrative for quite some time, since the 1990s, that there's sort of Christine Chinking and Jane Garden approach toward Hilary Charlesworth, saying that international law failed from a feminist perspective to take into account the women within international law as a whole, and some of the scholars have pointed to the evidence of that as being the lack of concern for gender-based violence, in particular, through the processes of international criminal process. But actually, what you're saying with your research is that that was present within the context of the examination and investigation. But was there a failure, or two failures potentially, that came from that? One, failure to prosecute those with as much public determination, or two, the failure of the international legal community to acknowledge that that's what had happened, and not having access to the archive, I think, was probably an issue there. And therefore, that notion of publicity, of that focus on the vulnerable, was lost in the intervening years. So some of that feminist critique is still strong, but sort of misplaced, not from the origins of law, but from the actual interpretation of law.
Yes, I would agree in terms of critique towards interpretation of law, but also acknowledging the existence of this collection archives. In general, that's my question to this resources, to this knowledge we can draw from UNWCC materials. What was the interplay between these cases and the Nuremberg trial or subsequent trials? Because some gender-based crimes or crimes affecting also women, their reproductive rights, as, for instance, medical experiments, they were persecuted at the doctor's trial. Also, the Ravensbrück medical experiments charges first from Poland, but then the British documentation we can see in the UN War Crimes Commission archives that are basis for the future prosecution. So it is a part of some body of sources of material which was known and acknowledged to the prosecutors, to the justice system at that time, 1945, 1949, or early 50s, but acknowledged or recognized only to some extent. What was the reason? It's hard to say. On the other hand, I choose these two examples from the Auschwitz charges concerning the extermination of Jews, deportations, extermination of political opponents in Auschwitz concentration camps. So very complex cases, very grave crimes with also some, I think, the gravity of crimes, also types of scale that was applied, also not recognizing gender-based violence as equal to other types of criminality, but also this individual factor of not reporting, not sharing facts and details on this crime was important. And when we read today's ICC policy on gender-based crimes, there are the same obstacles. These crimes are underreported. There is lack of complex view of intersectional analysis, also on the side of the prosecuting bodies. And on the side of the victims is fear, trauma, also hear from the how will it be or will it be accepted by the community, the stigmatization that may follow this type of accounts given to the prosecutors. So I think there were different. There are different components of this lack of acknowledging, lack of using this material, but still we can see that even if underreported or labeled with ill treatment, tortures, or some very general notions which not necessarily mean or we don't necessarily understand as rape. Under these charges, we can find cases and evidence of this type of crime. So to use this material, one needs to dig into the cases and also have some knowledge on possible scope of crimes committed within some crime complex. But even using the individual crimes, the one particular act of rape or forced prostitution that, as Dan mentions in his book, was reported by France but by Belgium, and is easy to find in the UNWCC documentation. It is a bunch of material that should have been used and was prosecuted in some cases after the war. And why was it forgotten or neglected? It's a very complex and problematic question. I think the question of victimhood and, of course, iron card in the political agenda, the political circumstances after 1945, Eastern Bloc states or Poland as well, the country that suffered that much, but on the other hand, under these new circumstances, wanted to present itself as survivor. Maybe it was also some factor, but that's like another topic for another discussion. These cases were prosecuted after the war, were reported and described in the UNWCC case law, were not that much present in the Nuremberg trial, where sexual violence is present, but the conviction doesn't include the act of rape as such. So I agree with this critique and would like to find more answers to this question.
About 10 years ago now, we had our first conference on the Commission, and along with Chanti Lasko, made a presentation we subsequently published about the crime of sexual violence in the work of the Commission. And Justice Goldstone, who was presiding, very kindly did a public mea culpa, saying that they had thought that they had invented this crime during the Yugoslav trials, and he was slightly put out to discover that, in fact, this had been prosecuted decades earlier without their knowledge in ICTY. I think a number of academic scholars today perhaps do need to catch up with their homework a little. Again, the 15 volumes of the UNWCC work, which do get cited, which have some 70 cases, published in a rush at the end of the Commission's life, and that these 70 cases are illustrative of the cases of the time, not comprehensive, and that there is a rape case there in the 15 volumes is a point to make. Secondly, a little examination finds that, as you pointed out, that in the Versailles list, and there's a blog about this on our website by one of our PhD candidates, items 5 and 6, I think, on the Versailles list of war crimes from 1919, list rape and forced prostitution, which is, and as the list, I think it runs to some 30 types of crime. It's quite significant that these were listed so high up at the time. Now, the student had done some speculation research, and there was a cultural image at the time of the rape of Belgium loomed large in Allied propaganda at the time, literal and figurative. And that may have had some reason why, in the culture of 1919, the issue was so elevated, one can say. But it's clear we did a statistical analysis with Leo for my book, building on the work with Chendilasco, and discovered some hundreds of prosecutions. Now, I think I would use the phrase that rape in World War II was prosecuted sporadically but routinely. That there weren't very many cases, but there were cases, and there was no controversy about the nature of the crime. It's also the case we demonstrate that, and I think you amplify this, that very modern issues, prior sexual conduct of the accused, for example, attempted rape, these issues are discussed in the cases considered by the Commission, which are a very modern flavour to them. So I think that these discussions should inform the feminist critique, but overall, and this I think speaks also to a lot of the work which I've been engaged in on other issues, is a lot of critical scholars to inherit a post-McCarthyite view of the Second World War and ignore, to our great detriment, what I would call the radical 1940s, which stretches across a range of different disciplines. And most notably, I had students who, a decade ago now, rediscovered the role of Brazilian women in establishing gender equality in the UN Charter. Not Northern women and not Eleanor, but Brazilian Dominican Republic delegates in San Francisco are entirely responsible for gender equality in the Charter. And that speaks, but that's ignored by feminist scholars, and our students, I have to say, in their article on this topic, rage against the critical feminist scholars who didn't reference their forebears sufficiently. So I think this is part of a broader picture of critical scholars accepting a conservative analysis of the 1940s at face value, and not appreciating the radical nature of the anti-fascist struggle.
Maybe I have one more additional comment to that. This qualification of rape as separate crime, not part of broader context crime or ill treatment or violation or abuse, because sometimes some cases are devoted to sexual violence but described with other crimes from the Versailles list. That was a question I was asking myself, why we have this two crimes in the 1919 list, which was accepted by the UNWCC and was the primary source of qualifying crimes when they were reported to the Commission. Why there are so few crimes of rapes or forced prostitution? The French charge I showed you from February 44. There are a few of them, and then there is a gap for over a year, and then again 2 or 3 cases, and then late 1946, 47, we can see the rise of cases reporting rape and devoted to this specific crime in very often broader context. I have the assumption that maybe the ongoing trials, but also preparation of doctor's trial of the Hamburg trials of the Ravensbrück concentration camp staff may have changed this view or somehow changed the attitude. We can see some cases that were divided into more particular types of crimes. So terrorism and persecution or ill-treatment, mass murders of the people of Zamość region or Pomerania region in Poland. Then they are divided into 3 charges with more specific charges and qualifications, and rape is listed as separate crime. So I believe the framework of UNWCC, this intention to unify this reporting system, also to find some common ground, is visible not only in the case of sexual violence, but they are suddenly appearing out from some larger cases there. So I believe that that may be connected with this cooperation and standardization of reporting for crimes and crimes.
Because the problem of the comprehensive nature of justice is that the whole systematic use of rape by the Soviet forces in their occupation of Germany is ignored in that history. So there's a separation there, and if that model of comprehensive justice means anything, it means that all perpetrators of these crimes are brought to book. But of course, that wasn't the purpose of the UNWCC, and nor was it of the scheme of justice post 1945. So there's an underlying flaw within the concept of comprehensive nature it's targeted.
I don't dispute that, of course, the Soviet Union wasn't part of this operation.
No.
And I'm afraid I don't have the reference, but at one point, if you search the 600 full trial transcripts of American tribunals, which are open to study by anyone who wants to look at them, there is a case of several cases of American soldiers being tried for the rape of German civilians.
Yeah, absolutely.
There's one.
There's
one. It comes up in one of the cited in one of the German cases where the defence is launching an argument. The prosecution says, actually, we just executed a GI for standing guard while his comrades raped a German woman, and he's just been shot by court-martial. So don't comment about your excuses for the behaviour of the German forces, and there may be others. And again, I know I'm saying it's attempting to say that there was a comprehensive response to the crime, but there's a great deal more attention. If I might, just on your very, very interesting prosecution outside of this forum, I would be interested to know what you think. Mark Ellis wrote an analysis of the UN War Crimes Commission from the perspective of fair trials, and I'm interested to know what you think about that, and particularly also the classified until 1990 report to ECOSOC from the Commission on the implications for human rights of war crimes trials, which itself is a title which, according to the standard historiography, shouldn't exist in the history or historiography of the 1940s. But nevertheless, they wrote a 300-page study on that, and they spent a great deal of time looking at the rights of the accused, the human rights of the accused in war crimes trials. And I wonder what you thought of those analyses.
Yeah, I'm not familiar with the Ellis's, so I'd be interested to look at that. But in terms of the report, it was very much focused on that sense, or at least part of it, on that idea that this was the counterpoint to the scheme of justice that was created within the Nazi regime. In other words, there were no protections, there were no senses of any kind of rights of the accused. And that was at the core, I think, of that rationale for creating a fair trial model. And it was pre-human rights instruments. It was constructed on that. And I think it was certainly the genesis of that idea of fair trial rights, which have progressed since then. They were minimalistic, I suppose, in terms of the rights that were granted in comparison to what we would expect today, but they were on that Anglo-American model of what any accused should receive in terms of rights. And I think that was a fundamentally effective way of trying to analyse what was an ideal position for a fair trial. I guess the difficulty is the distinction between the ways in which the trials were operated across Europe post-1945, whether those principles really were matched by the schemes that were adopted. And that takes looking at the individual trials concerned. So the idea of identifying the crime of association as being legitimate in terms of that model of fair trial of the accused was a fundamental one that was probably resolved ultimately in the idea that that wasn't acceptable. But nonetheless, it was part of the scheme of justice on those individual trials. So, yeah, I think that kind of analysis is absolutely essential in laying the groundwork for our international understanding of fair trial rights. But I suppose ultimately what it didn't do, and this might come back to Dominika's point, which is that he didn't really address the question of fair to whom. You know, it did push that idea that fair to the accused was the predominant model. He didn't really address that fair to both the witnesses, the survivors, the communities from which they came, any idea of fairness as how these matters should be prosecuted in the future. It sort of pushed its way towards that Anglo-American model of the rights of the accused. That's the fundamental, as far as my reading is concerned.
I have one more example that just came to my mind to answer to this comprehensive justice point. You are right, we will not find in these cases German victims, well, or not so many, but so the German victims of rapes suffered from Soviet soldiers. But what appears, and there are certainly different examples for how German victims are present in UNWCC case law. Of course, the crimes against humanity discussion is the one side, but the forced laborers, their relationships with German women in the right, because the crimes against the forced laborers is another bunch of crimes also involving legal discrimination, sexual violence as well. I found 2 examples of cases dealing with forced abortions or abortion forced. German women being forced to have abortion after being pregnant with Polish or Slav forced laborer in Germany. So these types of violence, this layer are visible and can be reconstructed and traced there. Although it's of course exception and again on the margins of some other case, but I believe there may be more these types of cases and abuses. And to the question of fair trials, I haven't read meetings of these commissions or the protocols, but of this committee of the Cambridge Commission on Penal Reconstruction and Development. But as far as I know, there was special subcommittee dealing with the questions concerning fair trials and the right of person accused and the rights of suspects. So that may be also some source to check and to ask whether these principles were then applied by the member states of the Cambridge Commission or then UNWCC, because there are some reports and questionnaires as it was in the case of war crimes or international jurisdiction. So
it's worth noting, we shouldn't spend too much time on this. If you look in the statistical appendices, which you may well have done, to the history of 48, the statistics on the trials give an acquittal rate of I think somewhere between 10 and 20%, which is roughly speaking, by any kind of domestic or international standard, is quite a reasonable rate of acquittal. And the commission itself, turned down probably a similar proportion of cases brought to it. So we shouldn't go away thinking that everything would simply rubber stamp kangaroo courts.
Yeah, I mean, I guess that was part of the problem, in the sense that at Bergen-Belsen Auschwitz trial, there were acquittals which created a storm of protest on the basis that SS guards were acquitted because the evidence couldn't pinpoint that guard's committing of an act of violence. So the percentages are absolutely right. But of course, the American approach in Dachau was very much, well, if you're an SS guard operating in Dachau, you are part of the system, and therefore you are guilty by association by being part of the scheme. And that was part of the overarching Jackson model, which is if they could prove the illegality of these units, the SS, etc., and you were a member of that unit, you were automatically guilty of being associated with that.
I wouldn't really describe it as a Jackson model, because he was building on inherited the model developed by the Commission, which took this view, and Herbert Pell brought the view of what we would perhaps in the English system call joint criminal enterprise, and I think in some of his correspondence, he puts it fairly plainly that if a unit comes in the middle of the night and massacres the village, being able to pinpoint Gefreite Grubel for what the massacre of that particular family is utterly impossible. But you can say that it was the 221st Company of the 3rd SS Division who rocked up at midnight and burnt the village to the ground and everyone in it, and therefore the members are liable. Now, I think whether that applies to every member of the Gestapo, which was proposed, perhaps is not a question. But personally, I think there's a good deal to be said for some application of joint enterprise.
Yeah, no, the genesis of it shouldn't be put at Jackson's door. You're absolutely right, but nonetheless, it's the adopted model that manifested itself. But it doesn't take away, I think, from that sense of, well, the acquittal rate is not an indication of fair trial operating effectively. What it is an example of a particular model of fair trial that it begs that question: is it appropriate in all circumstances? Does it match with the idea of comprehensive justice as opposed to what is inevitably always going to be selective justice? That's the nature of international criminal law. It doesn't really operate on the basis of comprehensiveness. It is based on the idea of selection. And that's acknowledged, I think, by the whole scheme that is being constructed of complementarity in the International Criminal Court today. It's selective by practice. It has to be, because it couldn't operate otherwise. But nonetheless, written within the DNA of that is this idea that everybody should be held to account. Now, if that is never going to be reasonably practical, then the foundations of international criminal justice are shaky. So we look at conflicts today. How really are prosecutions, if they are ever going to happen in the conflicts that we see operating today, what kind of justice scheme is going to operate? Is it going to be comprehensive? Every single operative engaged in what is now the kind of war crimes of indiscriminate targeting, for instance? Where does the nature of justice actually focus on? Is it going to focus on the leadership, so be selective? Is it going to be comprehensive? Everybody? So the end to impunity is the ultimate aim. These are the kind of practical questions, but also underlying philosophical questions that I think goes back to the theme of this, is that a real analysis and hard work analysis of what happened in 1940s and 1945 just doesn't provide that kind of weight of argument. Didn't resolve those fundamental issues. I guess that's the sort of more general underlying argument.
Mm-hmm. Very, very interesting point there. The kind of do we prosecute the individual, and then what about the role of the community in the commission of international crimes? Particularly if you look at group-based discrimination, genocide, crimes against humanity, in particular places in the world. So yeah, it does raise very serious questions, and particularly when you look at national level prosecutions nowadays for international crimes, and how it typically is, if we look at universal jurisdiction cases, it's typically low-level defendants who are present in the country because they have come to the state to seek, the foreign state to seek asylum. And so, but we're not, the universal jurisdiction has trouble, I suppose, with prosecuting the big guys, but you've got all these low-level officials who are regularly prosecuted. So yeah, very interesting perspective there.
Well, we certainly see that with the British experience of Iraq. You know, we see a tiny fragment of prosecutions. We see an ICC investigation which establishes that war crimes were committed within their reasonable viewing of the evidence. We see the ICC Office of the Prosecutor accept that the investigations were flawed at the beginning, but there was sufficient response post those initial investigations, but years later, which suggested that the UK was not unwilling to investigate and prosecute. But the practical result was there were no prosecutions for established atrocities that were committed. And systems of violence, detention particularly, detention practices have been established, but no consequences flow from that. And I think that's a product of that sense of not really resolving systemic issues, resolving the individual ones. So as you're right, individual perpetrators being identified from now and again, but it's always low level. And that link with the systemic responsibility is always cut. And that, if you look back to the UNWCC, that was something that was not going to be accepted. You know, going after the low-level perpetrator, you can establish, used a particular weapon that was in a particular place, guilty of an offence. That wasn't the aim. It was to make those connections.
It's precisely for these reasons why I think you see such resistance to accepting the work of the UNWCC till today, because in many ways it was much more advanced than we do today. You take, for example, the sorts of crimes that the British and the Americans prosecuted, and the French prosecuted the Nazis for, with respect to their subsequent behaviour, the French in Algeria, the Americans in Vietnam, but particularly post 9/11. And as my example is, while the world perhaps has too many American liberal lawyers, Mr. Trump would say, too many woke lawyers, none of them woke up to the fact that waterboarding was part of the indictments at Tokyo. And that wasn't used in rebuttal of the Bush administration's adoption of waterboarding. And water torture, as it was called, was used repeatedly in trials of the Japanese across Southeast Asia, and should have been used as a rebuttal to the waterboarding practices, but was never picked up by the liberal lawyers whose job it was to do that.
And the case, the Dulag Luft case, which was a prison camp operated by the Luftwaffe for downed pilots brought together for purposes of interrogation. The methods of detention and the methods of used to try and persuade people to give information that they weren't required to give is almost an exact replica of what happened in some of the camps in southeast Iraq. Their Dulag Luft case was prosecute those commanders who were responsible for the detention system that was operated. And once they established that,
I'm sorry,
they prosecuted.
I lost my adjectives, but I think it's extremely reprehensible that the supposedly progressive lawyers leading these issues today don't use this material.
Yeah,
because it's an absolute gift to use it, but for whatever reason they don't.
Yeah, I think it's ignorance. I think it is that academic.
Well, willful ignorance.
Yeah,
I have to say willful ignorance at this point.
Well, I'm just conscious of time, but I don't want to neglect people who are here with us in the room. Does anybody have a question for the panelist?
Anything online? Have we got any online people?
No questions online yet. Yeah, I'm keeping an eye on that.
We can add it to Miguel. I'll keep in mind to maybe this informal sessions and then. So, yeah.
Yes, go ahead.
So yeah, well, international. It's disgraceful that international criminal lawyers have not picked up on all these
evidence and use it more. And well, I have to, and the reason for rejection that you mentioned is unacceptable. I have two blog posts in the European Journal of International Law that have links to all the mentioned indictments, have links to, and I'm also an international criminal lawyer. I don't understand why there are not more international criminal lawyers pointing out the evidence that you point out. Just a couple of questions. Bilateral indictments, you mean like one state prosecutor?
State A against the leader of State B.
You also mentioned that the Commission adopted the rule discarding as irrelevant the doctrine of the immunity of heads of state.
That is their phrase from their minutes.
Okay. Well, we have, because one thing, I think they were more recognizing that there was no immunity. They were not saying
this is the phrase in history.
In the history of the United Nations.
That's the phrase.
Okay.
And then in the bundle of documents, the 2,000 pages, which are on the website, there are the minutes of the commission where they reached that decision.
I will go back to that on my presentation. So yeah, okay. The Polish law was applicable to crimes wherever they were committed.
You mean this decree I mentioned? Yes, it was independently from the crime scene. The norms were limited to crimes against Polish nationals.
Only against Polish?
Yes, under a violation of international norms, crimes committed against Polish nationals or Polish state.
So not universal jurisdiction pure.
Well, this was meant for the national prosecution, so internal law fact, but that was meant as part of broader program. So there will be international agreements, some code for international prosecution, which Poland will be part of, and was trying to make this kind of agreement happen or come to this conclusion, defining terms of prosecution on international level, but it was clear, and also the priority was laid on the national prosecution, on the investigations conducted by the national organs and before national courts. So this decree was for Polish courts after the war.
Maybe we'll go back then to the actual wording of the law.
And of course, there was the principle of departing from the lex retro non agit principle. So crimes committed after 1st September 1939 were to be persecuted.
Yeah, also, but staying in Poland, the Polish government has recently made some comments to the International Law Commission, where that's their word, they remind the International Law Commission of their indictments against Hitler. Yes.
I did not. That's wonderful news.
Yeah. And
that itself is worth a trip.
yeah, but at the same time, well, I don't know. At the same time, it doesn't dispute the arrest warrant decision, the personal immunity stance of the European Court of Justice, but it says functional immunity should not exist, but it seems to say personal immunity, which is a little bit like saying, more or less, like I violated international law when I indicted Hitler, at the same time that is reminding the International Law Commission of that violation. So I'm not sure what the position, the actual position on the existence of personal immunity for heads of state is the position of the Polish government. I don't know if you have any idea about that.
I'm very conscious of time as we're way behind. So what I'd like to do is I might conclude our this discussion. Chitty, you're more than welcome to raise it in the next time for discussion, or even at the coffee break. Yeah, I just want to get things back on track as much as I can.
We're joined by Professor Amina Adanan, who we heard from earlier, who introduced the whole show, and to whom we're very grateful for organising everything. Hopefully she'll be followed by Stefan Radojčić from the law faculty of the University of Novi Sad in Serbia, who will be looking at the role of the UNWCC in prosecuting former leaders for international crimes by means of an online presentation. And did that ping mean that we are now hearing from Novi Sad?
No, that was me.
That was you. Oh well, I'll keep trying. And to coin a cliche, last but by no means least, we'll hear from Dr. Miguel Lemos from the Faculty of Law at the University of Coimbra, Portugal. Where is that?
It's in the middle of Portugal.
That sounds great.
No, you're not asking where Portugal is.
No, I'm not American. Although the Americans now will go to live there. But sounds a wonderful place to be. Who will be talking to us about the relevance of Hitler's prosecution by the UNWCC for current debates. So that's grand, and that will take us up to lunchtime. So to coin a further cliche, or another cliche, I'll turn to Amina to talk about the UNWCC's institutional legacy. And she is actually surprisingly here with us in Maynooth because she is professor here in Maynooth.
Not professor yet.
Oh well.
Someday.
Sorry?
Only a matter of time.
Well, it depends on, I think, for large parts of the planet, anybody who has any university degree is a professor, so. That's right. You're a professor to me, I mean.
Thanks, Dan.
Let me swivel round.
Good morning, everybody. Before I start my presentation, I wanted to kind of stress that this is part of research that I'm working on with Dr. Dominika. We are doing some joint research on how the kind of structure and workings of the UN War Crimes Commission can lend itself to ideas of mutual legal assistance in terms of domestic prosecutions for international crimes nowadays as well. So just to flag that, this is one half of a larger research project. So this presentation starts with kind of a general overview of the UN War Crimes Commission. I know this morning we started in quite, the keynote speakers, we started into quite minute detail. I'm kind of paring it back a bit and looking at the structure of the War Crimes Commission as an early example of the principle of positive complementarity. Before I look at its legacy and what we can learn from it in terms of mechanisms for mutual legal assistance today in more contemporary times. So the first thing to note, in terms of the membership of the UN War Crimes Commission, you had at varying times up to 17 member states who signed up to the Commission for a start and also sent representatives to represent their state before the Commission. So you can see there quite an array of post-war allies. And each, as I said, each state was represented by particular individuals. So the first chairman of the commission overall was Sir Cecil Hurst, who was also mentioned this morning by Dan. And he, of course, was an eminent international scholar and lawyer at the time, a former judge of the Permanent Court of International Justice, being one of his achievements. The Commission's primary task, of course, was to investigate allegations of international crimes, to gather the evidence, and to compile a list of perpetrators as well. It was composed of 3 committees. Dominika this morning spoke about some of the specific work and detail of the particular committees. Committee 1 focused on facts and evidence. It liaised and received with the national offices from the member states. And the national offices submitted prima facie cases and evidence to Committee 1, which was then reviewed by Committee 1. Sometimes the Committee 1 felt that there wasn't enough of evidence there for a prosecution, in which case the National Office had to go and do some more work. So we have then the collection of evidence from that committee, which went into a central repository, which was another function of the commission itself. So you have this vast body of evidence that is collected in the central repository of the commission. In addition, particularly in the early stages, Committee 1 also assisted the national offices in conducting their investigations as well. And once the national offices or the Allied the states had concluded their trials, they sent summary reports of the trials back to the Commission via Committee 1 as well. So we have all this information that is then published by the Commission. Committee 2, on the other hand, focused on means and methods of enforcement. It was a body of legal experts who came up with policies for the Commission regarding the apprehension, surrender, detention, investigation and prosecution of alleged war criminals. And the proposals that it agreed on were then shared with and sent to the member states, who either agreed or disagreed, and for the most part agreed, well, a lot of the time did agree with the Commission's proposals. Committee 3 is of particular interest. It was a committee of legal experts who addressed vitally important questions of international criminal law, not just at the time, but ones that we're still addressing today. So they looked at things like immunity, they looked at things like jurisdiction, the definition of crimes against humanity, the definition of a war crime, and made a number of recommendations to the member states in those areas, some of which were agreed with, some of which were not agreed with as well. In a recent article by Leah Owens and Dan Plesch, they note how one of the questions one of the issues that Committee 3 addressed in detail was an early example of what we would probably now call genocide, but the crime of denationalisation. And they came up with definitions and what that crime should look like. So many issues that we're still addressing today were addressed in this by the important work of scholars at the time under the Commission. So one thing to note about the operation of the War Crimes Commission is the fact that it relied heavily on information and evidence it received from the national offices itself. The relationship between the Commission and the national offices of the Allied states was vitally important to the functioning of this international institution. In the early stages, the Commission actually aided Allied states, the member states, to create their national offices in the first place. And the relationship between the Commission and the national offices was key to its functioning. Another thing to note is, because you had this relationship between the national offices and the Commission, you had this influence in the work of the Commission on the work of national states. So we have kind of a top-down approach as well as a horizontal approach by the various national offices themselves. Some things that are particularly important to note is the sharing of information between national offices under the auspices of the Commission. So you have, again, an early example of sharing of information between the national offices, and that related to prosecutions or attempted prosecutions. You also had extradition that took place, particularly in occupied Germany, between the Allied states that occupied the territory, and they would transfer suspects between their zones to surrender to the relevant authorities for prosecution. So you really have, and of course you also have the member states who are enacting really important domestic laws in their legal systems that are allowing for the prosecutions to take place. So you've got this web of international criminal law being achieved on a national level, So it's really important to remember that, you know, when we talk about things like domestic prosecutions for war crimes, it is far from a modern concept. In terms of its legacy, I went through some of the statistics on the legacy of the Commission already this morning, so I won't repeat them. Vast body of information there, over 2,000 cases. We've got reams and reams of evidence, and not just that, but reports and minutes of meetings that were produced by the Commission that help us as scholars to identify and answer, or help us to answer some of the legal questions that we are still faced with today. What I would highlight in terms of its legacy is that, and this was touched on by one of the speakers this morning, was the influence of the work of the Commission on definitions that were of international crimes that were included in the Nuremberg or London Charter itself, and how, you know, that's something that's really overlooked in terms of the focus on the IMT today. Another thing to note in terms of its body of work is that it contributes to the formation of customary international law. So when we look at things like universal jurisdiction, when we look at things like, you know, the definition of a crime against humanity, questions around immunity of heads of states, all of the work that was compiled by the Commission, you know, all of that is feeding into the formation of our state practice and our opinio juris, and that's something that we really shouldn't forget as lawyers and as international criminal lawyers and academics. Important also to remember there were, of course, obstacles and limitations to the functioning of the Commission, some of which were already mentioned this morning. You know, questions around subjectivity in terms of prosecutions, questions around the difficulties in particular faced by some of the state representatives, particularly the US and British representatives on the Commission at various times had to either resign or of their own accord or kind of pushed out of the Commission because of the progressive opinions and legal opinions they were giving on behalf of the Commission, which were then not accepted by their states themselves. And that's particularly relevant when you look at the definition of a war crime at the time, which due to British influence on the formation of the definition was restricted to a war crime having to be committed against the national of an allied state, and thereby obviously excluding crimes that were committed by the allies themselves. So that's one. There was political influence asserted by the great powers at the time. Another thing to note was that there were difficulties and a slow release of information between the national offices and the Commission as well, because the Commission was obviously dependent on information it received by the national offices, which was at times slow to be received. So in terms of what we can, I suppose, learn from the UN War Crimes Commission, or how the processes and functioning of the institution has been adopted in various ways in more contemporary times, there are a number of modern day institutions that promote or work in a very similar way to the Commission, or don't. So perhaps the most prevalent would be the Eurojust Genocide, EU Genocide Network, which is a product of the European Union, of European Union law. And the EU Genocide Network is a network of prosecutors and kind of basically national offices in the member states. And member states are encouraged to set up specific specialised units to focus on the commission of international crimes. And often they look at other crimes like terrorism as well. But this network is kind of it's a meeting place for the sharing of information between those national contact points, those national offices, and more recently what has happened is the establishment of what are called JITs, or Joint Investigation Teams, under Eurojust and the EU Genocide Network. And these are specific teams of mostly prosecutors in the EU member states that where they come together to look at particular issue. So one was established to do with Syria a couple of weeks, or about 3 weeks after the war, the beginning of the war in Ukraine. One was established specifically to look at Ukraine, and what they do is it's a sharing of information between the members. There's training involved as well, and the EU Genocide Network and Eurojust are engaged in training of, for example, prosecutors, training of judges in the area of the prosecution of international crimes on a domestic level. So it is really probably, arguably, maybe the closest thing to the UN War Crimes Commission model that we have in contemporary times. Very recently, we have the establishment of a particular treaty, which is quite long-winded, and I will read out the full title now. So the treaty, it's the Ljubljana Hague Convention on International Cooperation in the Investigation and Prosecution of the Crime of Genocide, Crimes Against Humanity, War Crimes and Other International Crimes. This was drafted in May last year. There's been quite a slow uptake in terms of ratifications. But it has been years and years in the making under the Mutual Legal Assistance Initiative. So it's fantastic to see it come to fruition, and it's really, it'll be interesting to see how it progresses, but it establishes these national contact points in states that sign up to the treaty. And again, it's about mutual legal assistance in terms of the sharing of evidence, and transfer of suspects via extradition, and all those sorts of issues that the UN War Crimes Commission would have addressed decades ago. In terms of the central repository capacity of the UN War Crimes Commission and how that was one of its major contributions, the IIIM in Syria and the IIM for Myanmar, these independent investigative mechanisms that have been established by various UN bodies, and they are established to look at particular situations to gather evidence of the Commission of International Crimes for the purpose of compiling files for potential cases further down the line. So these are massive repositories that do feed into domestic prosecutions in mostly European states. So I suppose it could be argued on the one hand that they also have kind of a quasi UN War Crimes Commission function there as well. So I'm going to leave it there. Thank you for listening, and I look forward to receiving any feedback on this research. Thank you.
Thank you. So again, let us see if we can raise Stefan.
Yes.
Yep.
So we're delighted to be joined by Stefan Radojčić of the Law Faculty of the University of Novi Sad, who is about to present to us on the role of the UNWCC in prosecuting former national leaders for international crimes. We are all ready to listen to your presentation, Stefan. Do go ahead now.
Thank you very much. I've chosen the topic of the role of the UNWCC in the prosecution of former national leaders as a matter of legacy for the current proceedings or the possible future proceedings in the field of international criminal law. In that sense, I would briefly point out the historic background of the issue, knowing that before the World War I and at the relevant time, it was not almost disputed that Serbian head of states were protected by the immunity, and that there were attempts to prosecute Wilhelm the Emperor and some Turkish leaders, which have never been conducted. And turning to the most important point, the Nuremberg trial, it is very important to note that there was a irrelevance of the official capacity in the sense of conducting these proceedings, which was, if I may say, overturned approach in the following decades, up to formation of the ad hoc tribunals in 1990s, where by the statutory norms and the UN Security Council decisions or the acceptance by the relevant state itself, the official capacity was not the obstacle for the actual prosecution. And of course, we are all aware of the arrest warrant case. It's in a certain way narrowing the possibility of exercising of jurisdiction on the high-ranking officials. And finally, going to the very present moment and the actual situations, the International Criminal Court actually is in the focus of the paper and the presentation. There is, of course, relevance and importance of the general legal regime in international law when it comes to the possibilities of prosecuting national leaders and former national leaders, based on the principle of sovereign equality of states, as enshrined in the UN Charter. And on the other hand, we have very important and significant exceptions from these rules, some of which are very characteristic by its factual background. And we are now on the certain point of possibly very important upcoming decisions. In that sense, even in doctrinal sense, it is not univocally accepted whether the functional immunity is clearly material immunity and personal immunity only procedural obstacle. If you take in consideration texts of Professor Kasese, Shabas, Trichterer, but anyway, it is not the that kind of clarification. It is not essential on the point of actual exercise of jurisdiction. Turning to the relevant jurisprudence, there is a number of cases where there was no objection of immunity, and there is another group of cases where it was disputed issue, putting emphasis of the famous Pinochet case because of the fact that there the very character of the alleged crimes was essential for the final outcome in the sense of immunity. And now knowing that there is no statute of limitations for such grave crimes and that there are certain exceptions from functional immunity, there arises the question which exceptions are legally binding by default and in which situations it will be possible to prosecute high-ranking national officials in the future. As a matter of fact, I noted that even when it comes to the crime of the aggression, there is no overwhelming accepted opinion juris, even though and despite the efforts of the ILC, etc., whether it should be counted as a one of legitimate cases for such proceedings. Now coming to the ICC, there is a slight, let's say, discrepancy between Article 27 and Article 98 when it comes to the issue of immunity. It is specific because Article 98 relates to the non-party states and its officials, and actually it gives primacy to the general states' obligations under international law, and it is very important to know this, knowing the current tendencies in the work of the ICC. That further leads us to the very close relation between exercise of personal territorial jurisdiction if the suspected is national of non-party state. It further makes me think of whether the nomos of the earth is the determinant of the territorial jurisdiction of the ICC, or the extraterritorial jurisdiction will become acceptable in a manner as it is the case with the European Court of Human Rights. The ICC has its own standpoint on this issue, proclaimed when in the situation of Afghanistan, Mali, Bambara, etc., that it can prosecute nationals of non-party states, which on the other hand leads us to the analysis of the Vienna Convention on the Law of Treaties and its many customary rules codified in these conventions. At the latest, there are arrest warrants for serving head of state and prime minister, which are members of non-party states, and that is the very issue, whether there is growing or forming opinio juris on this, let's say, approach of the ICC, and whether it will be upheld by the state practice. And finally, whether the international criminal justice will overcome its identity crisis, as the Daryl Robinson said in 2008, or it will make it even more emphasized. To be more precise, I noted that among the relevant scholars, there is now talk about the so-called Gaussian moment theory, and the question whether all of these current tendencies are actually leading to the formation or modification of customary international rules relevant for this issue, whether there is fundamental change of context, whether the mentioned development is sufficiently clear, is it rapid, or is it only accelerated with its acceptance by the most powerful states coming from various legal systems? And finally, will it destabilize the international criminal justice, and whether some state could avoid such a scenario by taking persistent objection? All of these questions were elaborated by Professor Sharp with the pro and contra arguments, which I find very interesting. And to conclude, I see that the work of the UN War Crimes Commission left the great legacy, not only on the matter of facts and the research, but also as a constitutive part of the very foundational principles of international criminal law at the relevant time of the Nuremberg trial, and that there has been significant development of institutes over past 80 years, which has reached the peak in the last 6 months or last year, where there is an open question whether the ICC is actually building a new customary international rule, or it is making just an exception that could not be actually realized. And finally, will such a situation lead to the formation of a new ad hoc or hybrid tribunal on a bilateral or multilateral basis, and which jurisdictional basis and the legal basis should be used in the sense of formation of such possible tribunal? Thank you very much for your attention.
Well, Stefan, thank you for a very, very erudite presentation, one that would not shame a professor, let alone somebody who's yet to get their doctorate. Thank you for that, and also you get the prize for being not merely on time, but under time. So you get a double praise from me as chair. Now we're looking at infinite numbers at the backs of my head again. Thank you to Tech World. Stefan, if you can stay with us, we'll get the third presentation now, and then we can open things up for discussion. So, Dr. Miguel Lemos, as previously described, the floor, such as it is yours.
Thank you. So the title.
If you want to use it.
Okay. The title of my presentation today is the relevance of Hitler's prosecution, I don't know if this is the correct word, by the United Nations War Crimes Commission for current debates about the issue of immunity of heads of state. I believe I can say I've written quite a lot about the topic of immunity of heads of state. And in all my writings, I've mentioned the indictments against Hitler and their endorsement by the United Nations War Crimes Commission. But I have actually not dug into the actual indictments and what that endorsement by the United Nations War Crimes Commission means. That's what I propose to do here today. Before that, a couple of remarks. There is a widespread 21st century myth according to which heads of state have always, from time immemorial, enjoyed an absolute immunity from foreign jurisdiction. A decision of the International Court of Justice that we have spoken about in the arrest warrant case strongly supports that myth. According to this decision, heads of state enjoy full immunity from foreign criminal jurisdiction. Therefore, the prohibition to prosecute heads of state extends, and it has always extended, to an aggressor head of state, to the head of state of a belligerent enemy, and to heads of state who more generally perpetrate international crimes. We are talking about really an absolute immunity myth. This myth is not in tune with the long forgotten history of international criminal law that dates back centuries. As Larry May has noted, according to centuries-old assumptions and practices, sovereigns who perpetrated aggression would simply receive a capital punishment, either summarily or as a strong likelihood once they were brought before tribunals of the victim state or of other states. The same applied to those heads of state who perpetrated war crimes or other outrageous acts in violation of the law of nations, what we would today call crimes against humanity. According to such assumptions and practices, which are reflected in the writings of numerous of the most qualified publicists of the 17th, the 18th, and the 19th centuries, no special immunity was granted to kings or other heads of state with regard to these crimes. The absolute immunity myth is also not in tune with what occurred in the, during and in the aftermath of the First World War. At the time, the prevailing view, as reflected in an abundance of state practice and opinio juris, was also that there was no sort of head of state immunity with regard to war crimes or any other type of supreme international offense, as at the time was aggression was labeled. Since we are in Ireland, I just want to mention one rarely noted fact. During the war, and while the Kaiser was the sitting head of state of Germany, a coroner's jury in Ireland delivered a verdict stating in connection with the sinking of the boat Lusitania, stating this appalling crime was contrary to international law, and we therefore charge the German emperor for the willful and wholesale murder before the tribunal of the civilized world. Finally, the absolute immunity myth is not in tune with the national indictments against Hitler during the Second World War and with their endorsement by the United Nations War Crimes Commission in their aftermath, and even more importantly with the Nuremberg judgment, which no immunity principle, which is set out clearly in the judgment, undoubtedly was or turned into customary international law in 1946. As to the national indictments, in 1942, the Czechoslovak government issued a statement regarding all German crimes committed on Czechoslovak territory or against Czechoslovak citizens, emphasizing the personal responsibility of Adolf Hitler. He was charged by Czechoslovakia for murders, massacres, etc. perpetrated in Czechoslovakia. For the Czechoslovak government, the responsibility of Hitler does not need discussion. It is easy to prove. According to Czechoslovak criminal law, he is the perpetrator of the crime of murder and is punishable by death. For Belgium, Belgium charged Hitler for the assassination of numerous Belgians under the criminal law, the Belgian Penal Code. Belgium also charged, maybe a little bit later on, Hitler for the assassination of prisoners of war. The charges informed that the Belgian prisoner was amongst the ones murdered. Hitler was also indicted of pillage, confiscation of property, perpetrated not only in Belgium, but also in France, in relation to the theft of Belgian works of art. Poland indicted Hitler for crimes committed in Germany, Poland, and in other places, and it emphasized that the aim of the crimes was the biological extermination of the Jews in Poland, as Dan said earlier on. Poland affirmed that in having done what the present charge submits, Hitler has violated the paramount principles of international law, important, both written and non-written. The general principles accepted by civilized nations, the Hague regulations that Germany had accepted, and the laws of Poland. Naturally, in all these indictments, Hitler's name was always on the top of the list. Sometimes such lists comprised hundreds of other high, mid, or low-level accused, occasionally merely identified as the others. Hitler's name often appeared in capital letters with the number 1 attached, in bold or underlined. In no such legal document was that prominent position accompanied by any suggestion that Hitler would be entitled to any special form of treatment, immunity, etc., as a sitting head of state. If anything, that prominent position on the top of the list and the several remarks specifically concerning Hitler suggested that the sitting head of state of Germany was precisely the one person who in no circumstance would be entitled to immunity. Also important is that all charges against Hitler were not grounded upon any international treaty for the punishment of international crimes. The Nuremberg Charter only came later. Nor were they grounded on any idea that the new law on international crimes was to be created in the aftermath of the Second World War to ground such charges. Instead, the state practice and opinion juris enshrined in the charges was grounded on a manifest belief that pre-existing international law and national law were both directly applicable to and immediately enforceable against the sitting head of state of Germany. Do also note that at the time, international military courts did not exist. The Nuremberg Tribunal only came later. Thus, prosecution of war crimes perpetrated by whomsoever, including heads of state, was an issue that, as a matter of course, would possibly have to be handled by national military courts or indeed common criminal courts. The United Nations War Crimes Commission, constituted by 16 states, endorsed at least 7 separate indictments against the sitting head of state of Germany, based upon what Dan Plesch calls those formal charges. The fact that the Commission listed Hitler as an accused war criminal, subject to arrest by those 16 states, suggests that in the opinion of the 16 countries of the Commission, the sitting head of state of Germany was not entitled to any sort of immunity with regard to the crimes of which he was accused in those indictments. This constitutes state practice and opinion juris of those 16 countries. As emphatically noted by Dan, the United States endorsed those indictments. The United Kingdom did, France, India, China, the Netherlands, etc. The truth of the matter is that a great number of the indictments that led to the arrest of many of the major war criminals or other officials and their surrender to the Nuremberg Tribunal and other courts were issued during the war and while the persons targeted by the warrants were still in office. No one apparently suggested that Hitler or any other high official was entitled to immunity while in office, or that the proceedings before the Nuremberg Tribunal or other tribunals against certain officials could have been, in some cases, the result of indictments that violated international law at the time they were filed because the targets of the warrants were still in office. To the contrary, not only Hitler and apparently even Benito Mussolini appeared on the list of war criminals on several occasions while still in office, but also the Commission consistently expressed the view that war criminals would not be entitled to any sort of immunity. This view is reflected in an impressive number of surrender documents and other instruments calling for the arrest, transfer and prosecution of heads of state officials. Again, the state practice and opinion leaders enshrined in this endorsement by other countries of the United Nations War Crimes Commission cannot but have been grounded on a manifest belief that pre-existing international law and national law was immediately enforceable against the sitting head of state of Germany. Important word of caution here about Lord Bright's account in his 1948 history of the Commission. Wright describes what occurred in the Second World War as a profound alteration in the doctrines of immunity of heads of state. That's not what that work reveals. That work reveals that pre-existing international law did not recognize any immunity for heads of state. That is, in other words, Wright seems to, at times in his writing, seems to also believe the 21st century myth about a centuries-old immunity for heads of state. In sum, the actual charges against Hitler, as well as their endorsement by the 16 countries of the Commission, constitute unequivocal state practice and opinion juris to the effect that at the time, a sitting head of state was not entitled to any sort of immunity in relation to the conduct or crimes underlying such charges. This is the conclusion. Only two final remarks. All the indictments filed by Belgium, Czechoslovakia and Poland might suggest that prosecutions against Hitler in the courts of Poland, Belgium and Czechoslovakia were legitimate on the basis that the crimes were committed in their territory or against their citizens or interests. However, their endorsement by other countries of the Commission might suggest otherwise, namely that Hitler could be prosecuted for such criminal violations in the courts of any country in the world. This latter suggestion was subsequently endorsed by the Nuremberg Tribunal itself. As such, the endorsement by other countries of the Commission of the charges against Hitler is perhaps the greatest contribution of the work of the Commission for present-day debates about the prosecution of heads of state. In other words, just like Hitler could have been prosecuted by any country in the world, so can sitting heads of state like Vladimir Putin, Bashar al-Assad, etc. Okay, thank you.
Well, Manuel, your presentation was so powerful, detailed and coherent as to make me extremely jealous. Now, I hope, Stefan, you are still with us. And before I open the floor fully to questions, I wondered if you wanted to make any further comments, Stefan, on the other presentations that you've heard. Well, see if we can reconstitute you at some point. I will. Ah, yes.
I have some troubles with the camera, but I was also impressed by the presentations of the colleagues, and I'm eager to take part in discussion. So,
good. Did you have any question or further point you'd like to make yourself about the other presentations? at this point?
Well, I will yield the floor to the others, so we can
Okay.
do it interactively. Yeah.
Let's open the floor then to my fellow panelists and also to those in this expert group. So who would like to get us going? Chile, the microphone is on its way. Wait. You
Thank
have the
you.
mic.
I've got a couple of questions for Miguel. I think it's following up from our discussion last night. Our first question is, would there be a difference with the concept of equality of states and immunity?
Do you want me to answer it?
Yes, please.
So I believe that that's the origin of the myth. It's the schooner exchange case in the United States that first articulated the doctrine of sovereign immunity. Justice Marshall was careful to highlight in that case that the situation he was addressing was a situation of peace. He clearly insinuated that immunity for heads of state and for the state did not apply to these questions of war.
Thank you.
So the principle of sovereign equality in war disappears, something like that.
Well,
And you have a second question, Chidi, I believe.
yeah, I think I'm just going to bunch everything up and just straight at you and then see where you land with your answers. Previously, Professor Plesch had mentioned the ICJ, the arrest warrant, and you seem to agree with that. But one of my points is with the UN, the commissions, the indictments are different from convictions. And international lawyers, and particularly the court, will pay reference to convictions, decisions of court under their statutes. Article 38 to, I think it's 1D that says the court will pay attention to decisions of international courts or decisions of national courts. So where is an indictment? It doesn't translate as much as a conviction. And this also bears in mind or goes to the point that immunity is not a substantive defense, but a procedural defense for lawyers, right? And that the way equality works is that if a head of state has immunity in a second state because it's going to affect the equality of states, for instance, it doesn't translate to impunity because he can very well be prosecuted in his home state. That's where, of course, what the Americans have done recently. The Supreme Court will give Professor Plesch a ground to stand on the immunity question. But the key point is that is there no distinction between national courts and international courts when it comes to immunity? And do we also pay attention to that development of international law, international criminal law from the 1945? Post-1945, the laws were different. War was actually illegal, foreign policy too. Post-1945, war wasn't, and all the concept of international law really developed after that. How would you say, use the history of pre-1945, and then how would you translate it to the core development of international criminal law and immunity from 1945, particularly between the ICTY and now?
So, well, as for me, immunity has never existed before. So international criminal law comes from further back, and we actually have cases of heads of state being detained, being indicted in national courts before the Hitler's case. Napoleon I, Napoleon II, III, well, one of Napoleon's was exiled, etc. But, well, so immunity, there were no international criminal courts at the time. So there was no immunity, so national courts could prosecute an aggressor head of state and a head of state at war with themselves. So, and what happened is that in 1999, in the Pinochet case, the House of Lords came up with the idea that heads of state are entitled to a personal immunity, not functional immunity, but a personal immunity. No one had ever used those distinctions before with regards to international crimes.
And then in the arrest warrant, the courts said, okay, yeah, personal immunity for a foreign minister, and of course for heads of state and heads of government, but no immunity before certain international courts. And of course, the International Criminal Court picked up on that idea to say, well, there is no immunity before me. In a decision that I find borderline the intellectual dishonesty, the International Criminal Court in Jordan referral against Jordan tells the same story that I told, but instead of telling, but it adds one thing. This proves that there is no immunity before international criminal courts. A story that has nothing to do until the First World War with international criminal courts. The court uses that to prove that there is no immunity specifically before international criminal courts. So I guess, and states accepted the decision of the arrest warrant and of the International Criminal Court, and so maybe today there is, in fact, immunity before national courts.
We do need to make sure that our answers to questions aren't longer than our presentations. But great questions, Chidi. Amina, do you want to join in?
Yeah, just to continue on what Manuel was saying after his really interesting presentation. Another thing to consider as well, particularly around Article 27 of the Rome Statute, is, another reason. Well, obviously that the provision allows for the non-recognition, or that there states that immunity isn't a barrier to prosecutions under the Rome Statute. But another reason for that, the rationale for that position, is the fact that states, when they sign up to the Rome Statute, they're consenting to that. So that's another aspect of I think of what you're saying, that we've got that treaty. If we bring it back to the basic laws of international treaties, that's another thing that's relevant there, and because that is, I suppose, at odds with the position of the International Court of Justice in the arrest warrant case, if you're trying to reconcile the two. But something else to consider there.
Thanks. We are running into our lunchtime, but we'll run on a little bit longer. I do want to make a very swift observation, which I think that the increasing use of universal jurisdiction, which we see around the world in the last decade or so, when combined with, let us say, restoring the idea that there is no immunity, does provide quite a powerful set of tools for improving international justice, and for that reason I think we may anticipate some last-ditch resistance because these two things taken together I think can really be quite powerful in eroding the horrible problem of immunity and impunity by state leaders. But I'm heartened also to hear, and Dominika may want to add to this, that I understand that the current Polish government has reminded the International Law Commission of its indictment of Hitler during the Second World War, possibly as a result of our colleague Patricia in Warsaw. Can you enlighten us on that at all? Don't want to put you on the spot. Well, I am putting you on the spot.
I cannot done, but we have our colleague experts to ask that question. But speaking of this topic, one small remark to the discussion on the sources of this concept of prosecuting Adolf Hitler, head of state, in UNWCC cases. It follows this whole discussion about lacking accusations, lacking evidence material against state leaders. That was in 1944, and accusation against the Commission that there are no proofs of guilt of the state leaders Adolf Hitler member of the German government that the Commission is failing in that respect, and this development of methods or arguments of establishing this individual liability was a very important point of discussion in summer, autumn 1944. And I would argue that the concept of criminal group and recognizing the German government as criminal group, which was one of Commission's conclusions, was the path to prosecuting or accusing also Adolf Hitler and other members of German government. So there was no vacuum. It didn't come only from the national law of the member states, but of rules discussed and also agreed by the Commission in 1944. I wanted to ask Amina a question about this UN mechanisms, instruments aiming at protecting victims and documenting crimes in different conflicts and the demands of criminal prosecution. How do you think the newly developed instruments can contribute to effective prosecution of this large number of perpetrators? Only in Ukraine we have already thousands of reported cases of open prosecutions of individuals accused of different types of violence, and it's not the only conflict. So how do you think will this be possible to implement this universal jurisdiction in these cases? What are the limitations and options for these instruments?
That's a really good question, Dominika, and thank you for that. I think that the problem of that I think Andrew mentioned this morning was that the way the international criminal legal framework is structured is we focus on the individual and to the neglect of maybe trying to catch more fish in the conviction. It's just by obviously the focus on the individual that is one of the flip sides of that. And when we talk about universal jurisdiction, I was at a conference on universal jurisdiction in the Netherlands last month, where one of the panels was prosecutors in European countries who are the people who are prosecuting before domestic courts in their respective countries. But the point that they some of them spoke about, like what they take into account for when they're thinking about going after a particular person or prosecuting a crime, and it's evidence. Is the person usually who's present in their country? Do they have access to them? And there's a number of considerations. But among those considerations are obviously the likelihood of success of a conviction. So all of these are factoring into the decision as to who is prosecuted for an international crime committed outside of the foreign country, and it's those criteria or those factors that are taken into account that are, I guess, resulting in low-level defendants who are present in the country. They're not heads of state. They're not the people who came up with the plan to annihilate a particular group, but just have other people to do it. But another thing that was raised was the fact that when it comes to universal jurisdiction cases, when you're seeking a prosecution, it's much easier to prove the connection between the individual and the crime if the mode of liability is actual commission, is the person, you have the person who has committed the murder and the act. You have them rather than the person who's higher up the chain who maybe came up with the plan, who may be entitled to some sort of immunity. So again, these are all the factors the prosecutors have to take into account when they're deciding in the contemporary times whether or not they're going to conduct the prosecution. And the problem, the wider issue that results in is we have low-level defendants who are prosecuted rather than the big fish who aren't even in the country in the first place. And interesting to note, I was just double checked it there, but very recently, like within the past few days to week, Germany has changed its laws on universal jurisdiction, on its code on crimes against international law, to remove functional immunity for heads of state. So, you know, that's progress in this area when we're talking about the likelihood of prosecutions against heads of state in national courts. But a big factor that we all have to consider when we're talking about immunity and we're talking about national prosecutions for international crimes in contemporary times is the fact that political repercussions and diplomatic repercussions of attempting, not even prosecuting, but attempting to prosecute a head of state in another country, and what that means for the foreign state. Because it is a factor that is taken into account in prosecutorial discretion, whether we like to admit it or not. So that's something really that we have to factor into this possibility as well. Yeah.
Thank you. Andrew, you have the honour and dangerous role of having the last question before lunch.
Right, so I'm regretful. I've just two questions. The first is on whether the myth of immunity from prosecution is something that was actually bought into by the powers prior to 1945, and for good practical reasons. So, you know, Rudolf Hess was under arrest, in effect, detention from 1940 onwards. He wasn't brought before any kind of court, although he could have been, under the idea that there was no head of state immunity. Similarly, there were very few, and I'm trying to track down how many prosecutions that were taken place before 1945. The only one of any kind of war crimes, the only one I can find is in Lampedusa, a detention centre that the Americans pursued. And the key concern was that there would be reprisals whilst the war was still being fought. So there was a sense that this myth of immunity was supported by the Allies, at least as regards until victory was achieved. So there had to be victory. And of course that associates that idea with victor's justice, which has been this underlying critique, or however poor it is, of Nuremberg ever since. So I just wonder whether one needs to do more work on the idea of the myth, recognising that there was this sort of rationale perhaps for not pursuing any kind of criminal process whilst the war was still going on. It had to be victory first. And the second question really is one for the investigation, and it's just a sort of observation in the sense of, has the approach of investigation transformed dramatically since World War II, in the sense that the definition of war crimes has been vastly expanded with the idea of weapons being indiscriminate or targeting against civilians. And that inclusion in 1948 with the Geneva Conventions and its subsequent development actually has transformed our understanding of war crimes. So that what we see in Ukraine, what we see in other parts of other conflicts, is that a significant amount of concern has been civilians caught up in some kind of military action, and trying to establish some kind of complicity there for the deaths of civilians through failure to distinguish between targets. That wasn't something that the UNWCC, as far as I know, I mean maybe your investigations would indicate otherwise, that the UNWCC really addressed, because obviously there was indiscriminate bombing on both sides. So that development, has that transformed our notion of what is investigative, and what can be investigated, and how it can be investigated, and who is responsible? The person firing the missile, launching the missile, firing the artillery shell, or the person who's in charge of the determination to attack civilian territory.
Might I abuse my position briefly and answer? First of all, I don't think it's accurate that there was nothing was said to be done about war crimes until after victory. Well, individuals weren't picked out. From very early on, Roosevelt and Churchill and then the St James's Declaration made it clear to the Axis that there would be international criminal consequences for their actions. And the Commission was very careful to point to the Versailles list as having been agreed by Germany and Japan, and therefore having not being victors' justice. Your second point was on, sorry, my brain just fused. Discrimination.
Yeah.
There was a debate in the Commission on the question, this is where Dresden comes up, perhaps, where there was an argument between the Chinese and the Western Allies, keen to defend their bombing, and of course we never prosecuted the Nazi Luftwaffe for bombing Coventry or the Blitz. We regarded that as legitimate, and they boiled down to the question whether it was a defended target, and the Chinese were saying they were being bombed indiscriminately because they had no defence. But the Anglo-American position was targets of no military value. That their target had to have military value, and if it didn't, then that you could pursue that. And of course, the ability to be precise, was very much more difficult then.
Sure.
But nowadays, the other end of the spectrum is that the French will argue without blushing that their development of precision weapons is entirely driven by the concern to be more in accordance with international humanitarian law. And this is the entire motivation for France's precision strike programs, which is the other end of that. But anyway, I've abused my position, but let's see if our colleagues here, and particularly Stefan, want to make any concluding remarks, and then we'll hop to lunch.
Just two things. So a question has come in for me on the chat.
Oh yes, please.
But just to respond to Andrew's point about the change in investigations, so the answer is I don't have a kind of a direct knowledge of that. But what I would say is that the nature of definitions of international crimes has substantially changed, obviously, as we're all aware, since the UN War Crimes Commission. But so has the nature of evidence as well. I'm thinking we're in contemporary times of like digital evidence and how there's just that is just so prevalent nowadays, and the role that has had to have been adopted in investigation standards and even chains of trying to prove that evidence hasn't been tampered with, or videos were shared, and all of that. And not to say that the UN War Crimes Commission didn't have similar issues in terms of the standard of evidence, but I suppose there are similarities in I suppose issues in terms of the collection of evidence that arose then that still arise now. But I suppose obviously the change in definitions is going to substantially change how investigators do their job. Sorry, I don't have too much to add to what you're saying, which is I totally agree with what the point you're making is. The question that has come through for me on the chat is on the legacy of the UN War Crimes Commission as an institution. Does this mean international crime prosecutions will be prosecuted in national courts following cooperative investigations? That's a good question. Is that what you were suggesting when you mentioned positive complementarity? Actually, no, that wasn't what I was suggesting. Well, first of all, thank you very much for asking that question. What I would say is that in terms of, I think you might be the speaker or the commentator might be speaking about my point about joint investigation teams, particularly under Eurojust, and how that in modern times allows for cooperation and mutual legal assistance between different national prosecutors and offices. As far as I know, because there's actually not much public information known about the JITs. What I do know is that they hold regular meetings, they share information, but it's very much based on the countries conducting their own prosecutions separately. That's not to say that I don't know, because I'm not party to these conversations and things like that. And as I said, there's not too much publicly known about how they operate in
in practice. But what is known is that it is a meeting of prosecutors and experts who share evidence, problems, both or issues that they come across, both on an informal and a formal basis. So it can be very informal, the exchange between the national offices as well. But I don't know, maybe in the future there might be cooperative investigations, and it would be very interesting to see what that would look like and how it would function. But as far as I'm aware, under the JITs, that it's a coming together of interested parties, but the countries are conducting their own investigations and prosecutions. But I hope that answers your question, and thank you for that.
Was there another one online? Or?
That's it for now online.
Brief question.
Very, very briefly. It seems, I think it's rather natural that you are focused at that time on winning the war and leaving the prosecutions to later. You speak about the sense of head of state immunity that could have existed at the time. From all the documents that I've read, the sense was no immunity. So I would have to see where that sense of head of state immunity comes from, because in all the documents, no immunity seems to have been the.
Stefan, have you got any last thoughts for us?
Thank you very much. I have two remarks. There was a mention of the treatment of a group of the perpetrators and the German government in its entirety. And I would just like to draw attention to the German concept of so-called Organisationsherrschaft as a mean of treatment of the collective or the hierarchical responsibility, which is to some point similar to the Common Responsibility Institute. But in my humble opinion, it is more clear and simple. Whether it is matter of mentality or the legal tradition, I'm not sure, but it is to some point used in terms of the criminal responsibility of multinational enterprises. And the second one is related to the bombing and victory's justice, etc. It is a tricky question, and I just would like to mention the two-Koke principle, which was to some point used before Tokyo Tribunal, but more certainly by the lawyer Otto Kranzbühler, who was defending Admiral Dönitz. And when it comes to the bottom line, it is again tricky argument, because it can lead to the egg and chicken dilemma, stating two quoque and two quoque, and if the facts are not perfectly clear. Thank you very much.
Well, thank you very much for those. I think now we've taken half our lunch break. We will reconstitute that at 1 for those who want the make sure who are online to join the final panel. So I hope you'll join with us in thanking our panelists present and in Serbia.
Good afternoon, everybody. You're all very welcome to the afternoon session for the workshop on the UN War Crimes Commission and its contribution to international criminal law. So for the next panel, our final panel, as I said, we had a slight change to the program. So this panel, it consists of 4 speakers. We have Dr. John Sedman, Dr. Chidi Nmaju, Dr. Clare Francis Moran, and we also have Dr. Federico Fredel Mesa as well. So the chair for this panel is Professor Andrew Williams, who's with us today. So Andrew, I'm going to hand over to you.
Okay, thank you very much. So I will try to be as unobtrusive as possible and let the speakers take the floor as quickly as possible. Do we have Dr. Dawn Sedman from Nottingham Law School who's available? Is she here?
Yes.
Excellent. Hi there. We're just on the screen. So if you, I think you have, we get the infinite. Oh, there you go. Hi, we can see you, which is great. So we'll try to keep to time if we may. Dawn, but if you'd like to
start as soon as you're ready. I think we might as well get on with it.
All right. Yeah. No. Thank you very much. I'll just proceed. So thank you very much for the opportunity to speak today. Wonderful papers so far. I wanted to have a look at a set of trials that I hadn't previously had a look at, but also that I was unfamiliar with the whole kind of Far East theatre of war. I think the Far East, in my perception, is an area of the trials, whether it's at the international level, so the military tribunals, the international ones, or the ones under the umbrella of the UNWCC. Often the Far East trials are overlooked. Very much the focus is on the trials related to continental Europe. So that was the reason for my looking particularly at these this collection of judgments and decisions by these trials. Just by way of a brief introduction, just because I'm conscious that others like me may be unfamiliar with them. Even though as we heard this morning, the UNWCC was set up in 1943, the Australians had actually started gathering evidence and preparing for post or after the end of the war trials in a year before, in 1942, and the reason for that was connected to an atrocity that happened in Papua New Guinea, and they started gathering evidence around that, and then other atrocities were happening in a similar area, and so they again similarly gathering evidence around those. Evidence, mostly documentary evidence, some verbal or written witness statements and things like that. So they've been gathering this since 1942, and then obviously when the UNWC was set up, they joined and became a part of became under that umbrella. They had somebody who ended up being quite significant at the International Military Tribunal, heavily involved in their preparatory work for these trials. That was Justice Webb, who you may all be familiar with in the sense of because he went on to become one of the judges at the Tokyo Tribunal. But he was quite heavily involved at the domestic level for a number of years, leading up to the establishments of the trials themselves. So he wasn't involved in the domestic prosecutions. The other thing, and again, this kind of links to what we heard earlier, is that the Australian government introduced a national legislation to enable these trials to take place as soon as the war ended. The War Crimes Act of 1945 and the Regulations for the Trials of War Criminals 1945, both of these were introduced with the express purpose of providing jurisdiction to prosecute these war crimes at that national level. What is notable particularly about these provisions is that they move away from the more regular, more stringent, shall we say, criminal justice approaches to prosecuting crimes. And that's really reflecting a pragmatic reality that particularly gaining evidence in that wartime environment was difficult, was hard to do. And so they were a little bit, shall we say, looser in terms of their criminal evidence and their standards for criminal evidence that they would be ordinarily. And there was a much heavier reliance on written evidence. Now, if we think about this in terms of fair trial and concepts of fairness within procedure, then immediately that's a little bit problematic, because for the defence, because then the ability to be able to question, particularly the writer of the evidence, is much more tricky. There's a greater reliance on written evidence. So there were some issues there, but as I say, it was really a pragmatic response to the environment in which this evidence was being gathered. In terms of composition, just to kind of conclude the general introduction to this, the personnel who were involved in these trials were very much military officers. It's very much kind of military courts, though often they're not all, but often they had legal qualifications attached to them. So some of the judges, I think there was an expectation that at least one judge on the panel of judges who heard the cases would have a legal qualification. Similarly, the prosecutors, the defence, they would have legal qualifications too, but they were in the main military officers. There was an ability as well for them to co-opt as judges, other allied power officers as well, if they essentially didn't have enough to fill the bench, but predominantly they were Australian. The prosecutions were for war crimes only, unexpectedly, and of the 300 or so that are recorded, the majority of them relate to murder and to ill treatment of prisoners of war. That seems to be the predominant two areas of crimes. The victims needed to be either British subjects or a citizen of an allied power. So those were kind of the jurisdictional boundaries. The sentencing options there were three options for sentencing. So one was the death penalty, one was imprisonment, and it could be of varying lengths. And they did use, if you look at the records, they did use all ranges from 6 months through to 20, 30 years and life imprisonment, or a fine. I didn't see the fine being used at all, perhaps not unexpectedly. Death penalty, or kind of 10 years, around that kind of level of sentencing seems to be the most kind of common sentences that we see. And there was a process of appeal. So again, if we're thinking about fair trial rights, that's quite a pleasant thing to see. It was essentially a paper appeal. So the idea is that the defendant could petition to the Australian Chief of the General Staff, who was the most senior military officer, for a review of both the finding and the sentence. So either or both. And the Judge Advocate General would provide a kind of a report to complement that appeal against the finding or the sentence to inform the Chief of General Staff. The findings were rarely overturned. More commonly, though, the sentences were, and the sentences often were lessened. What is interesting is when you look at all of the results in terms of the 300 odd cases that there are, you can actually see some consistency in terms of the sentencing, and consistency that comes out as a result of that kind of process of the petition and the appellate stage. So there was a consistency check in terms of the sentencing itself. And the appeal process was with kind of a separate person from who'd been involved within the trial. So again, thinking about kind of an appearance of fairness within the process, at least, there does appear to have been an attempt at that. And I just mentioned that there were about 300 trials in total, but obviously far more individuals were prosecuted, over 800, because many of the trials were multi-handed. Roughly 2/3 were convicted and roughly 1/3 were acquitted, which is slightly higher than that figure that we heard earlier today, in terms of the Australian trials. Of those that were acquitted, they tended to be acquitted. The majority of them was because of a lack of identification. So essentially the court could not be sure that the person who was being prosecuted was in fact the person who the witnesses had identified as being the perpetrator. So it was an issue around identification. As was mentioned earlier, I think by Andrew, it's absolutely true that acquittals don't necessarily equate to fairness of trial, but I would say it's a positive indicator that there does appear to have been an effort to interrogate the evidence that is being presented, and at least to appear to believe that somebody's innocent until proven guilty. So I think the acquittal rates can give us a little sense of that. So in terms of the superior orders, this was commonly raised throughout these 300 odd cases, and commonly raised by particularly those junior officers. So a lot of the cases that we look at are, as I said, murder or ill treatment of prisoners of war. So often you would have a commander who would be telling those kind of lower level soldiers, kind of privates and corporals, in terms of their mistreatment or the killing of prisoners of war. And it was often those lower level soldiers who were claiming that they were just following a superior order, often by a superior who was there, who was very present at the time that the killing was taking place or the ill treatment was taking place. There's a fascinating article that came out just last year by Orbach and Bora by legal historians, which some of our room may be pleased to hear. So going beyond lawyers, but looking at legal historians, who have wrote a wonderful article about the use of superior orders in Japan and in the Japanese military prior to World War II. And what was clearly understood was that the superior was responsible and not the junior. So the concept of having a defence based on superior orders was very much embedded within Japanese military law. And it was there for reasons of military discipline and military obedience, this absolute expectation that those junior would follow their superiors unquestioningly. So that kind of very absolute understanding of superior orders. This was obviously very different to the approach that was taken by the UNWCC and by the Australian prosecutors and the findings of the judges themselves in the trials. There, the opposite was very much true, that responsibility applied to all, regardless of rank and whether there was an order or not. There had been discussion around whether that kind of the Japanese understanding could be incorporated or brought into play in any way in terms of using it as a defence. Another great article by Fellows and Chong looked at this in some depth, but in the concept of the Tokyo Tribunal, so the International Military Tribunal for the Far East, so a few years later, but essentially pointed out that a number of lawyers who were working in that tribunal noted that it wasn't particularly clear in terms of the evidence of customary law that it could serve as a full defence or not. So there was evidence to suggest that it could, evidence that it was only in relation to sentencing. Both potentially could be argued, but MacArthur's office, like the approach of the UNWCC trials, was quite firm that it would not be seen as a defence. This then meant that the perception of for the junior officers was that they were faced with a trial. They had a defence that in their domestic law would have been kind of recognised and accepted, and was not going to be recognised and accepted within the trials that they then faced. So there's a very different, a very opposite perception in terms of the doctrine and its effect in these prosecutions. The quote that I used at the top was to try and fathom, when I looked in the Australian cases, as to whether there was any concept of international law by those more kind of by the Japanese officers, particularly the more kind of junior ones, whether there was any evidence that they had had any kind of training in it or any knowledge of it. Because I guess it's one thing if you're kind of very clearly trained in terms of your kind of domestic military code, but do you have any awareness of those kind of global or those international norms in terms of these principles? Now, the quote itself, which is quite dramatic, I think, about international law, comes from Sagawa, who was an officer who was charged with the ill treatment of an Indian prisoner of war, and this was his kind of reaction when the Indian prisoner of war, who himself was an officer, was essentially being told that he had to take part in like a work party, and under the Geneva Convention of 1929, he was exempt from that by virtue of being an officer. He pointed this out, and the reaction that he got was the quote that you see in the title, Sagai's kind of dismissal of international law. It's mentioned a little bit in international law, so there's a little bit in some of the cross-examination that is provided within the records, but there's no real depth as to what the extent of the understanding was, particularly in relation to this particular area of law. And I think it's always worth remembering that whereas today information is something that, assuming that you can access it, say through the internet, and that you have the accessible ability in terms of your kind of knowledge and understanding and know where to look, you can always find an answer. Whereas obviously back then it would be much more difficult to be able to fathom. You'd be much more reliant on what you're being told, for example, in your military academy or something like that. So it is interesting to think about whether those junior soldiers genuinely had any perception that superior orders might be dealt with differently in a different context to the one that they were being kind of trained in.
You're just about out of time, Dawn.
Am I? Okay.
Yeah,
well, in that
case,
so no, that's fine. Can I just say, just to conclude then, because I was going to say that what happened is that where there was any mitigation in terms of the raising of superior orders, that was really shown in the use of sentencing. So for the person who ordered and who was perceived to be the most responsible, they would invariably get the death penalty. But for those who were more junior, especially those who had made some attempt to challenge the order that they'd been given, then they would be given a lighter sentence. And by lighter, I mean it's still a penalty of imprisonment, but it was definitely lighter than the worst one, which would be the death penalty. And that, if we're thinking about legacy, that's kind of continued to today in terms of modern international criminal law practice, obviously not with the death penalty, but the more serious life imprisonment or a longer imprisonment versus a lighter level of imprisonment. And obviously Adamovich is quite a well-known example of that. But I think really just to conclude, what I really wanted to get across here was that another aspect of this legacy is this disparity between what happens when you have one norm or one standard at the international level and one at the domestic level, and how that affects then the quality of the justice that you then feel that you are enjoying, and whether that could lead to a sense of injustice, particularly on the part of the defendant. You know, what are we seeking to achieve with our processes? Is it a speedy justice, appearance of fairness, a process using international law, evidence submitted, defence offered, a process of appeal, which all of these things had? But what about the defendant within all this and their genuine understanding in terms of the law that would apply to them and what law they can deploy in terms of their defence?
Thank you very much indeed. Okay, we'll be able to review the questions as we get to the end, but if we can move to our next speaker, who is Dr. Chidi Nmaju from SOAS. If you'd like to get ready to present, you have the floor.
Thanks. I think I'll rather stay here so I can have a good look at the time and not be cut off.
Yeah.
I'm going to presentation.
Sure. I'm just going to put up the closing slide.
Right. So I was looking at the UNWCC, the Commission's work on Ethiopia. As notable scholars, particularly Dan, has expressed in a recent article that the Commission has been lauded as a crucial developmental hub for the then emerging new practices of international criminal law. This paper particularly is a draft paper of an article working together, collaborating with Professor Plesch, but this is a draft, mostly by a part of that draft paper. So what we're exploring here is some of the limitations, if you put it that way, of the Commission, particularly with the Ethiopian trials. And we're doing this focus on Ethiopia is mostly within that historical context, such that the decisions or the activities, operations of the Commission was at such a time that there was an emerging international legal regime, and then the wider political state of international legal order was just kind of in its formative stage. So putting that in perspective with our findings, our discussions. So we've first looked at what are the key variables to examine whether these were challenges or these were failures. And looking at those key variables, we'll move on to the paper. We'll also try to investigate or kind of pick up plausible lessons from the failure, if you may use that term, or limitations of the Commission with regards to the contemporary international criminal justice regime. And then finally, we'll look at whether there were also crossover lessons for international criminal law, particularly in reference to Africa's challenges with international criminal justice, notably with the ICC as a whole. Right. So going on to the first stable variable that we've picked up here, it's as Dr. Amina Adanan explained earlier eloquently, the workings of the Commission, which we're going to rely on the first variable, which is more like how the Commission facilitated national action. So the Commission did not itself prosecute, right? But they facilitated national action based on those three committees. And in this sense, how would the committees work? How it would have influenced or impacted the decision not to prosecute or not to carry on with the charges of Italian leaders in Ethiopia? So facilitation of national action, looking at it from the Commission, and then Ethiopia. How was Ethiopia? What really were the situations within that country that led to the decision that could have influenced the decision not to prosecute? The second variable is the idea of institutional inequality. Now, the Commission was based in London, three committees, as we said. In the role it acted over the national trials, you could say it would be more like different institution, but it had its role to play, a supervisory role or peer review role, as some may put it. The purposes of the investigation and reporting meant that the system was reliant on that dual approach, dual between the national and the Commission itself, based in London. These variables will kind of come into play when I'm looking at the lessons we could have learned, or we are learning from these. All right, so moving on to plausible lessons from these failures. The first one is the power politics. Understanding from what we've discussed earlier about the structure of the Commission, the structure of the work, and the reliant on the big powers. Recall earlier that I think it was Dr. Adanan that explained to us how the Commission was made up of 17 countries, right? Mainly. Ethiopia, of course, wasn't there. A couple of these countries were not there. Well, the key voices in making up the decisions for the national actions, some of them, there will be a disconnect in the translation, or a disconnect between the presentations and the decisions in the long run. And so this power politics continues to play a role in contemporary international criminal justice in various ways. The second idea, the second lesson, or it's these conflicting principles in international criminal justice. At the time, it was peace, stability in Europe against justice outside of Europe when it comes to Ethiopia. And in different ways, these conflicts of diverse principles or diverse concepts continue to play a role. You often see it in my next point, which would be selectivity, which some of what Professor Andrew had mentioned earlier about the fairness of the system and where the system is not fair or whether it's fair. How do you define the contemporary system of international criminal justice with challenges such as this? Now, we must know that, we also must recognize that international criminal justice is a system fraught with the politics of the international order in its own. it's not a perfect system, the order is not perfect. And so there is always that influence of politics, and there's always this juxtaposition of justice against politics, justice against other principles. And the key drivers of this is national interest. And so in that situation of Ethiopia, where the pressures and conflicts were not at the forefront of the decisions, but underlying those decisions, these interests were considered. For instance, the UK, US, were not so much in supportive of Ethiopia's cases for reasons, various reasons. One was justice, one was reprisals against allied prisoners of war. Another one was ensuring that the current leaders in Italy, Bergoglio, were cooperative with the allies while they were in power, as against what objective and what national interests were they going to obtain from pushing through prosecutions in Ethiopia. So those conflicts will always be there, and they currently are there in international criminal justice. Now, I must note a caveat here. The fact that there were no prosecution in Ethiopia by the Commission does not equate to a failure of the Commission. The ICC has variously failed in several trials. I mean, taking 10 years or 9 years to prosecute President or Vice President of Kenya, and another leader in Congo, and then come up with acquittals, or sometimes they not even get through the trial. The next lesson I'll move on to, which is the third one, it's I think what I've referred to that earlier, selectivity and national interest. So the concern of challenge of selectivity continues to pose, continues to be a big issue with international criminal justice. It's not such that it's not a standalone principle. It's not specific to international criminal justice. It's also seen within domestic criminal justice systems, where in domestic systems we could use the term as prosecutorial discretion to cover the idea or the principles behind the prosecutor deciding or declining to pursue prosecution within their domestic system based on national interest and a couple of other principles. Now, at this point in time in the Commission's work, there wasn't really any such thing as those principles being developed and things were still in play. Considering the time, I'm still going to fly on to, let's see, last part of my or this presentation would be what are the lessons that we could draw to contemporary international criminal justice, especially in relation to Africa. And I will note that there is a concern with the capacity and resources. Now, Ethiopia didn't have the capacity, neither did it have the resources, which currently plagues that continent in Africa and a couple of other countries. And so, putting that in play against the Commission's decision, you would say that if the Commission had gone ahead with the prosecution in Ethiopia, another set of problems would have emerged, which would be concerns within the, of course, carrying out of justice in Ethiopia, what are the models of justice in Ethiopia for those kind of trials, and other logistics relating trials in Ethiopia in a system where they probably didn't have enough. In fact, the Attorney General of Ethiopia was a Dutch man, right, at the top point in time. So the capacity wasn't there, the resources weren't there. So the lesson here is one of the need for Africa to resolve its own capacity resources. I suppose that Africa is doing its bit to try and resolve some of these, because it's set up the African Court of Human and People's Rights, which kind of tries to kind of make up for resources-wise, capacity-wise, particularly at the time that it had challenges with the adjudication of international criminal justice before the ICC. Another issue is in situation where Africa is unable or unwilling to prosecute, as in this case, well, the term of an inability to prosecute wasn't used because complementarity wasn't seen as a core principle, or wasn't even developed as a core principle then, but it was in practice, in de facto, an idea that was running through the UNWCC in a sense. So age inability would have meant that the trial would have had to be carried out, effected somewhere else, or what? So there were other challenges behind the non-prosecution of declining to prosecute by the UNWCC. I know there's a few other plausible points that are positives from the failure to prosecute or non-prosecution, and I'll round up saying that if we look at the 1947 treaty, as Professor Plesch had mentioned earlier, and there are positives in which the Ethiopian action, the negotiations, Yugoslavia, Ethiopia led to phrases being included in that treaty based on the work around the prosecution of the Italians for crimes committed in Yugoslavia, Ethiopia, and other places. Thank you for listening to me blabber around Ethiopia, and thank you.
Thank you very much, Julie. Well, that was exactly on time, so well done for that. Next, we have Dr. Clare Francis Moran from the University of Aberdeen. Are you there? Sounds like a bit like Eurovision.
Good afternoon.
Yes, we have you.
Hello. Can you hear me okay?
Yes, we can hear you very well.
I'm going to talk about today is the criminalisation or the lack thereof of slavery prior to the Second World War, and then the way in which the UNWCC looked to Nuremberg to try and further define a lot of the crimes against humanity and war crimes, and then the way in which Nuremberg didn't really, or the IMT rather, didn't really, the International Military Tribunal, didn't really go into much depth. And then the way in which sort of the evidence of crimes perhaps weighed on the interpretation of these crimes, as well as the previous laws in the area, and some tentative conclusions on the impact this has maybe had on international criminal law. So the criminalisation of slavery is something that we would take for granted now, hopefully, but prior to the Hague Conventions at the turn of the 19th, 20th centuries, and the period before that, in which there had been an awful lot of money effectively made out of the trade in human beings, there was a reluctance somewhat to formally condemn the idea of slavery as a crime. So you can look at the writings of Gladstone in 1840, which was at a relatively early stage in the discussion, and then Oppenheim as well, his treatise on international law in 1912, both refer to the moral violation that is slavery, although Gladstone then goes ahead and is very much of his time, as it were, by saying that it is also a great branch of commerce. So they seem there's a difficulty there in distinguishing between the moral violation that slavery was and the fact that it was also used to make a lot of people very, very wealthy at that point in time, while profiting directly from the suffering of human beings. So when we look to the law very much is focused, and the wording of the law is very much focused on eradication rather than criminalisation. There is what Bassiouni and Cassese, both international criminal jurists, who would refer to as implicit recognition of the criminalisation of slavery through reference to punishments in the Brussels Act and the Berlin Act, or the General Act of the Berlin Conference. So these international legal documents do make reference to penalties and punishments, but stop very much short of calling it criminal. The Hague Conventions, which were used by the UN War Crimes Commission, and to a certain extent the IMT as well, they both are traced by Bassiouni in particular as, or rather the criminalisation of slavery can be traced in the view of Bassiouni to the Hague Conventions in 1899 and 1907, because he determines that the ban on infringements of family honour and rights and individual lives, that would qualify as ban on slavery more generally. But again, nothing explicit. And then the 1926 Convention focuses on words like suppression, eradication, banning, forbidding, but not necessarily criminalising, although again, there's reference to penalties. So while that might not seem very significant to anyone who's not a criminal lawyer, it is so important to be able to characterise something as a crime. The characterisation of it was of criminal acts in general is a key criticism which is still levelled at the Nuremberg tribunals. If it wasn't criminal, then you can't be prosecuted for it. So we have an emerging difficulty here of a failure to criminalise. So then the UN War Crimes Commission looked to, when they were developing their work in this area, they looked to identify where the sources of law might be for these criminal acts. They looked to the Hague Conventions, and they also relied on the Versailles List, as many of you will know from the 1919 Convention. But what they relied on, what my work is looking at the moment, is a particular reliance on the preamble to the Hague Convention of 1907, in which the idea is that the law, so the Hague Convention 1907 notes that the law, in its preamble, not in the main text, but the preamble, that the law is insufficient, and therefore at that point in time, and until they were able, the drafters were able to codify the law of war more generally, there could be a reliance on any principles which were drawn, and I quote, from the laws of humanity and the dictates of public conscience. And this, in its own way, mirrors the comments of Lord Atkin, who's well known to law students in the UK for being one of the judges in the Donoghue against Stevenson case, but he was also instrumental in the UN War Crimes Commission, and he warns against this idea of being too legalistic. So the 1907 drafters almost have this kind of understanding that they won't see the worst that humanity can do at that point in time, and again, there shouldn't be an entirely prescriptive approach taken. So in the committee discussions, the legal committee discussions at the War Crimes Commission, rather than then being prescriptive and following on from Lord Atkin's approach, they then say, well, actually, we should wait and see what the IMT say about these crimes, rather than prescribing exactly what we mean by, for example, enslavement and enslavement as a crime against humanity, slavery or slave labour as a war crime, and so on and so forth. So again, there's this kind of aversion to prescription, effectively, which is not an enormous issue for international lawyers, but is a massive issue for criminal lawyers who need that degree of prescription for the prosecution to be fair, a concept which has emerged in recent times, which many of you will be familiar with, as this idea of fair labelling. The crime has to fit what has been done. So what's really interesting about that is that if you then refer to the interpretation of the crimes in the Nuremberg judgment, there is an enormous amount of evidence which details the slave labour policy which was pursued by the Nazi government. So they detail extensively exactly how this has happened and how the Nazi government pursued in minute detail the idea of not only the enslavement of individuals, but the enslavement of nations in order to fuel their war machine, in order to achieve the aims that they sought to achieve in Europe more generally. And again, there's in the Nuremberg judges have recourse to this more general idea that when inhumane acts, as you can see there on the slide, are charged in the indictment where they're not war crimes, but they've been committed in relation or in execution of the aggressive war, then they can be considered crimes against humanity. And that was where I got the title from, this idea that the crimes and the criminal acts are too well determined to admit of argument without going into any detail about what they are. So that then allows us to return to the UN War Crimes Commission to see, well, what did the domestic courts say about slavery? The case files that I've looked at so far have, again, enormous evidence of enslavement as part of the Nazi policies in certain countries more than others. So, for example, the Czechoslovakian files have an enormous focus on the slave labour policy because their citizens in particular were affected really significantly by the pursuit of this policy by the Nazi government, the regime. So the War Crimes Commission allowed reliance on domestic law as well as international law to demonstrate the illegality of the act. And at this point in time, you have already the Slavery Convention from 1926, so you would hope that there would be some sort of domestic law there to allow for the prosecution of slavery as a crime at the domestic level. But when you look in particular at cases under the Czechoslovakian Criminal Code of 1852, there is reference to the Slavery Convention as part of the indictment, but not within the domestic law. Instead, when they're looking at ill treatment, at acts of slavery, they refer to them as acts such as public violence. So there's not a great deal of focus on defining it clearly or saying, actually, this happened and this is why it should be a crime. So in short, at the moment, and I would think it worth to be corrected as well, but at the moment, there's been no evidence of a significant development of concepts and no direct relevance to the criminality of slavery as a specific act. So what does this mean for modern law and our kind of modern approach to international criminal law? Does this represent essentially a failed opportunity in which we now have a problem wherein there is a lack of criminal law around this area and international criminal law in order to codify the acts and prohibit them and ensure that the convictions are effectively safe when they're gained? Or does this maybe demonstrate a slightly progressive approach? So essentially, the approach of characterising slavery as a crime has been followed by the drafters of the Rome Statute for modern law. That's part of the law under the Rome Statute, which can be applied then by the International Criminal Court. But what they've also done is they have retained this idea of other inhumane acts. And what this has done most recently is it has allowed for forms of slavery which maybe can't be pinned down that clearly to be indicted and prosecuted by the International Criminal Court. And the case that I'm referring to here is the case of Dominika at the International Criminal Court, wherein the International Criminal Court were able, or the Office of the Prosecutor rather, were able to characterise forced marriage as a crime of an other inhumane act. It wasn't up to them to characterise it as sexual slavery alone, which was part of the act, nor was it a sort of simply domestic slavery. You know, it's forced marriage is conceptualised by the judge in the judgment and by the discussions in the case as being a uniquely awful form of slavery, because you have these elements of sexual slavery, but you also have these elements of domestic slavery as well, with the veil of a socially acceptable relationship the size of a marriage. So you have a really appalling crime which can't really be defined adequately by slavery, but falls very clearly within this idea of an other inhumane act. And consequently, the broader approach taken by the Rome Statute allows for this to be criminalised and identified clearly. So whether or not this constitutes, the approach of the UN War Crimes Commission constitutes progression in respect of looking at the horrible things that can happen during armed conflict and say, well, we shouldn't prescribe too heavily, whether or not that represents progression or failure in the sense that we are not being clean enough and allowing for these ideas to be criminalised very clearly and very openly is something that I'm not quite certain of yet. Thank you so much. I look forward to discussing this further.
Thank you very much indeed. Well to time as well. Okay, our final presenter is Dr. Federico Fredel Mesa from Colombia. Are you there, Federico?
Hello, everyone. Thank you so much for having me. I'll try to share my screen as well. So hold on one second.
So you have about 15 minutes.
Thank you. Can you see my screen? I think you can. Perfect. Okay, so thank you so much for having me. Also, thank you everyone for this very interesting panel. My proposal was called Hippies at Nuremberg, Polish Deforestation as a Claim Against German Occupation and International Environmental Law. Of course, this title is a bit tongue-in-cheek. We'll see why in a second, but basically my idea and the context behind the reason why I chose to delve onto this subject is the fact that within my work, and this is a bit of a personal note, within my work within the General Attorney's Office of Colombia, we have seen various different perspectives on how environment is treated before international criminal law. We have within the General Attorney's Office of Colombia several different macro cases which regard either regional territories or specific thematics of violence, and one of them is case number 5, which involves violence in Southern Cauca and Northern Cauca and Southern Valle del Cauca, which are 2 regions with a very high indigenous and African Colombian population. The biggest theme that we have seen regarding the environment is the fact that they see environmental harm as much graver to their survival, as well as just as a threat unto itself, than the general population does. And therefore, this brings a bit of an interest in how different courts throughout history have perceived international damages and how they have perceived environmental damages. And the biggest thing I saw, and I thought it was fascinating, was the fact that in Poland, there were some cases regarding the environment as a whole. So basically, this is a general context that I wanted to make. International environmental law has a long history, but maybe unfairly, it has been regarded as a recent development of United Nations law in order to stop global warming. Of course, this is a fundamental part of what international environmental law is, but it limits a lot of its scope when we see other cases in which international environmental law has been used. So basically, I wanted to make a very brief recounting of other elements of international law that recognize environmental damage as either a crime against humanity or a war crime. International criminal law does provide for an article in which environmental damages are seen as a war crime. However, as part of Article 8b of the Rome Statute, these crimes are seen as war crimes only in the context of international armed conflicts and not non-international armed conflicts. And general international criminal law, specifically the statutes of the Yugoslavia and Rwanda tribunals, do not have any specific provisions or regulations for environmental damage. This is not the case in international humanitarian law. There's been several different regulations on how environmental damages are seen, and this is where the Polish cases really come into light as explanations of damages to both written and non-written and international humanitarian law. Today, there are customary international humanitarian law rules that talk about serious damage to the natural environment as a grave violation of international humanitarian law. However, this has not been completely well developed, which means there is a lot of space left regarding this analysis. And then finally, we do have international environmental law proper, which involves both UN conventions, which are those we often see as the core of international environmental law, as well as other conventions, such as the Nmaju Convention, which prohibits modification of the environment within an armed conflict, and the Convention against certain conventional weapons, which also tries to block extensive and damaging and wide-lasting attacks against the environment as parts of the conflict. This leads us to the point of how is the environment perceived, and I think this is a very fundamental ontological point of how do we see the environment within an armed conflict. And generally, I think there's been 4 main theories on the perspectives of international law. The first one is maybe the most traditional one and the one we might be most used to, which is nature as property. Here we see nature not as a legal good to be protected in and of itself, but rather a legal interest that deserves protection because it belongs to somebody or because it is somebody's property. When nature is protected, it is because it belongs to someone, and the person that is wronged when that nature is damaged is that person, it's its owner. An example can be seen in the in the War Crimes Commission within the Belgian dossier. There is plenty of regards to environmental harm, but it is mostly done against farmers who have seen their territories either for wood felling or for agriculture damaged. The second point, which is maybe the most common nowadays, but it's still growing, is the anthropocentric point, which provides that nature is in and of itself a legal interest to be protected. However, it is not because of some fundamental ethereal importance of the environment, but rather because of the large importance that humans have on the environment. Often, under this perspective, nature is seen as a collective legal good or interest to be protected of a single nation or the world. And my thesis or my argument will be that this is the perspective upon which the Polish claims against Germany for deforestation fall under. The third, which is a little bit more developed, is the socio-environmental perspective, which sees nature as a legal interest to be protected because it is part of a network of interactions that include both humanity and society, as well as the environment per se. So there is this back and forth between humanity and the legal communities, which lead to the importance of protecting nature. And we can see this a lot, or I have seen this a lot in my legal work in Colombia. It's maybe the largest school of environmental protection in Colombia. We have seen it both by the Supreme Court protecting the Amazon River and the Justice and Peace, which is the special tribunals for paramilitaries protecting the Magdalena River. And then finally, there's the ecocentric perspective, which defines nature as innately worth preserving because of its own nature, not because of any importance to humankind. The environment becomes a subject of rights per se, and maybe even a legal person per se. We can see this mostly in indigenous and native types of law, but also in the Colombian Special Jurisdiction for Peace, which is a very interesting development. There has been some literature both in favor and against this idea, but it's still very new, very novel. We'll see how it develops. Now, specifically, the War Crimes Commission talks about damage to Polish forestries. Basically, as a general context, of course, the general government of Poland, which was the name for the Nazi administration of most of Poland, not all of it, a big part of it was directly integrated into the German Reich, was the most brutal occupation of an East European nation, other than, of course, the Soviet Union, which experienced constant fighting. Amongst other things, Germany attempted to abolish Polish statehood, in part by eliminating any claims to Polish ownership. Therefore, they passed the Polish Property Ordinance, which was a wide-scale expropriation of lands that belonged to the Polish state and to Polish civilians. And by the end of the war, they had passed several different regulations that prohibited any people of non-Germanic descent from owning territory within the general government. This basically meant that a very large portion of Polish land was administrated by an office based in Berlin, which was in charge with pillaging the Eastern territories. And amongst other things, the Polish government and Polish individuals after the war denounced that there was no care taken at protecting the nature of Polish territory. Of course, the Nazi Germans had a reputation for being technically protective of the environment, but of course, this wasn't the case in their occupied territories. And in Poland, it was a specific and concerted policy which intended to abolish the possibility of the Polish state to exist by and of itself and make it dependent on German colonization. This was seen as a way to Aryanize or Germanize the land. The biggest piece of legislation involving this was the Forestry Expropriation Ordinance, or literally Ordinance on the Public Management of Agriculture and Forestry Operations of 12 February 1940. It involved general expropriation of all lands that weren't held by ethnic Germans before the 1st of September of 1939, the German invasion of Poland. Instead, its administrator was a general administrator, or Generalbewachter, of the properties, with a right of management of the lands, but not a right of selling the lands. This all provided for an appearance of due management and regular expropriation within the German legal framework. As we know, Nazi Germany was very interested in showing its different forms of pillage and oppression as legal. This was another show of this, but the compulsory administration and expropriation of Polish agricultural and forest land essentially aimed at exterminating the Polish people, which could no longer sustain themselves, exterminating the Polish natural resources and making them dependent on German colonization and making all of the goods in Poland fit for the German war effort. Therefore, when the war ended and the charges against German civilians and German military officers were put forward, we see several different cases in which deforestation becomes a major part of the charges. The first of these is charge 36, which is in dossier 16. It's the Radojčić et al. Decision, which calls out the brutal liquidation of Polish property in the western provinces of Poland. These are the provinces that were directly annexed into the German Reich and experienced the heaviest form of Germanization. And of course, this applied to the land as well. They saw the land as something that needed to be Germanized or integrated forcefully into the German economy. There are 214 people that are charged for brutal economic policies against Poland. And specifically, they talk about the forests, which they mentioned they were subject to rude expropriation, being cut down carelessly and completely. There is a very clear differentiation between the charges brought against private property and the charges brought against public property, with those charges being landed against public property being seen as specifically harmful to the Polish nation as a whole, not the Polish state as a legal person, but rather the entirety of the Polish nation, in the sense that not only did it remove their chances at survival, or maybe limited the chances at survival, but it also attacked the patrimony of the entirety of the Polish nation. We can see this more in Real 18. In the Scheller case, case 1307, Scheller was the manager of the forestry department of Lublin. And this is maybe the strongest place for an anthropocentric view of the environment. We see an expropriation of the Lublin forests. As we know, Lublin is in the east of Poland and was under the general government. And this included a massive devastation of the Polish territory, including mass felling of trees and wanton destruction of public property. What's important about this case is that they emphasize that a part of being a vital base for the national economy is a greatly influencing factor of the atmospheric, ethnographic, and hydrobiological conditions of the country, and that the effects of these expropriations and the large-scale felling of trees, which was not controlled and not limited, was catastrophic and would take years or decades to be rebuilt. There is also, interestingly, a brochure by the Nazi government that is mentioned in this case, which shows that there was knowledge about the harm being caused to the Polish environment and that this was a purposeful policy. It's also important to note that the Lublin forests are some of Europe's most untouched ancestral forests, which makes this damage very important, not only for Poland as a nation, but for the general public, although this is something that I am inserting later on, and it might be something of an anachronistic statement to make. Then there's the Danner case, case number 1309, which talks about wanton destruction of forests by the deputy county officer for the district Gawrolin, which is also in eastern Poland and under the general government, and led to plundering of lumber. Here, there is more of a focus on nature as property rather than an anthropocentric focus, but it's important to note that there were also wide-scale damages created to the Polish population that included slave labor and the use of falling trees as a weapon of murder against Jews. So I think this all shows that under the different reels, we can see different perspectives towards the environment, but we can see an evolving perspective that denotes the fact that protection of the environment under the guise or the appearances of protecting the nation as a whole and seeing the environment as a good to be protected in and of itself because of the good it brings to the diversity of the nation, its biological conditions, and its ecological conditions already existed in 1945, and it's not a recent development. This is also mentioned in Real 38. Basically, they mentioned that the expropriation of the property and its exploitation ruined Poland economically and ruined it for a long period, and that this is an affectation towards both written and unwritten rules of law. And basically, as a last point, I would like to mention that I would like to further develop this perspective. I think it is a very interesting discussion of different views of environmental harm. However, of course, these particular cases were tried not in Nuremberg, but rather in Poland itself, which means that unfortunately I do not speak Polish, which makes it a bit harder to continue this investigation. I do think it's fascinating to see how different perspectives on the environment are being discussed, even in 1945, and how there's different perspectives that really come through. And this is not only a thing of maybe differing perspectives within native systems and transitional justice, but existed even far before within international criminal law. This might be very constructive to future transitional justice processes in order to develop historical memory on how the environment became important. We have had issues in Colombia regarding this discussion, so I think it is a fascinating one to have. And that's all. Thank you very much, and I'm sorry for taking 30 seconds over my time.
That's quite all right. Thank you very much, Federico. Now, questions from anyone? Yeah, let me pass the mic.
Yeah, well, very brief questions. To Chid, I don't know if it has anything to do with it, but I was thinking about what I said about Mussolini, that he was placed on the war criminals list. It was something to do with Ethiopia or not? I'm not sure.
No. Maybe since I'm the only one. Sorry. Mussolini's case was kind of determined internally in Italy before the Ethiopian cases. But there were charges really against Mussolini, but mostly against Benito and the other generals that ran the show in Ethiopia.
There were charges?
Yeah.
Against Mussolini as well?
I'm not exactly sure about Mussolini because his case was determined before the Ethiopian war crimes, the commission kind of made the decision in Ethiopia because he had been executed before then, right? So that may
I've never looked, but I've never come across it, although he is stated that history says that he was listed as a war criminal, but I've never gone looking.
Okay. And just to Federico, I'm writing about the possible crime of ecocide. Could you share your slides with us?
Yeah, of course, I'd love to.
Thank you.
I was wondering which email could I send it to? Just if you could, someone could write it on the chat or something.
Yeah, if you want, you can send it to me, Federico. So if you send it to my email, amina.adanan@mu.ie. So if you send it to me, I'm happy to share.
Okay, thank you.
Yeah.
Perfect. Okay, thank you.
Excellent.
I actually
Amina, yes.
sorry. Don has a question there. Don.
Sorry. Thank you, Amina. It's an observation for Clare, and it was your mention of Onwen right at the end, and the fact that forced marriage and other inhumane acts, and how you classify certain crimes or which crimes an action can fall under. And it made me think a little bit of some of the cases that I had a look at in relation to the Australian trials, particularly thinking of the Burma Siam, so a number of prisoners of war were used as forced labour to create that railway. It's quite a famous example, I think. And they were all prosecuted in terms of murder and ill treatment. So formally, but it struck me that actually what they were doing was effectively slavery, because they were forcing them to work without pay. So there is an evidence of something that could be classed as slavery, but is being charged as something else. Now, I'm afraid off the top of my head, I can't remember whether that's because there was no recognition of slavery within the War Crimes Act that Australia introduced, so whether they could prosecute it under that crime particularly, and if there was that, whether they chose to prosecute it as murder because they were making some kind of statement that is their preferred kind of descriptive criminal act in relation to what was done to those particular criminal those particular prisoners of war. I don't know, but it struck me that there was evidence of slavery taking place. But if you look at the files formally, you can't see that in what is being prosecuted, at least in the Australia example that I had a look at. So it was just an observation. Sorry, there was no question there, but it was just an observation about how prevalent slavery was as a crime being prosecuted and whether it was actually there, even if it wasn't being prosecuted.
Thank you very much. And I haven't had a chance to look in much detail at the domestic cases, and this is, but it supports what I think is the case in that they are calling it one thing when it really is another. But whether or not that makes any difference is something I'm not really. So thank you very much. I'll look into that.
I just had a question for Chidi. Thank you for your presentation, and thanks to all the presenters for that really informative panel. Chidi, I was just wondering, out of interest, when you were talking about Ethiopia and the efforts that it went to try and prosecute Mussolini in particular, where are the archives held for the Ethiopian attempts, or for their, like, did they have a national office set up, or I'm just wondering structurally how did it work, and then the flip side of that is, where are their records? Are they on the UN War Crimes Commission website? Are they stored somewhere? Are they in the Wiener Library in London, or where are they?
Yeah, well, for the Ethiopian one, it's quite it kind of goes back to the problems of capacity and resources. See, because there was really no national office. It's much more difficult to get more information on Ethiopia. And so thanks to DANS, the archives, where you get a charge sheet, Ethiopia probably would never have been discovered as far having been heard, really, or even gotten that platform to being investigated by the commission itself. So it's kind of more of desperate measures, relying on mostly of the archive and a few other articles, historical articles on Italy, but from the Italian side. I think Dan has made some efforts in Ethiopia to try and get the archives across to Ethiopia. And we did, while I was doing it, I had an Ethiopian assistant working with me who actually made efforts to try and get some information in Addis, but nothing really is available in Addis Ababa. So most of what we gathered is still we're still working on it though. It's still mostly from London, and I don't know if Dan has anything to add to this.
There are, there are committee discussions of Ethiopia, which are indexed by the Commission, which you can find, and there are the National Office's correspondence with Ethiopia is a file, and that includes correspondence from the Ethiopian Foreign Ministry to the Commission up to 1948. So they keep banging on the door. After the peace treaty, they finally are allowed to take them forward, and then they send in a dozen or so dossiers against, I think, 10 Italian officials, Badoglio and others, in short order. But then, of course, they're doing this in the window between getting their cases heard, and the door slamming shut on the Commission forever. And clearly, the American State Department in particular, Ms. Fight, are adamant against this, and the British as well. And there is some other secondary literature. There's a professor, or I think a doctoral student at UCL, and if you look it up in Google Scholar, there are a couple of other people who've written about this. I think we mentioned in the thing I do with Lear, which eventually will be published by Humanity before time stops. I wondered if I might, Federico, I just wondered if you could just briefly restate what you see as the contemporary relevance of the Polish forest case. Just very specifically, I know you said it, but I didn't quite grip it.
Yeah, it's maybe a bit specific, but generally, transitional justice has had issues, especially this goes a bit further that maybe it can be explained briefly, but Colombia has a very complex legal system for imputation of war crimes cases. And there's been quite a bit of discussion regarding whether environmental damage constitutes a war crime that deserves punishment within Colombia's special jurisdiction for peace, or whether it deserves amnesty. The argument being that as it's not a crime that is prosecuted by the ICC, there is no threat of complementarity being invoked, which means that Colombia can declare an amnesty for it either way. This has been very strongly challenged within constitutional law and within victims' communities, both of which see nature as a fundamental legal good to be protected. Specifically, Native communities have seen the damage to their environments as tantamount to genocide, or the term that they like to use is ethnocide, because, and this is another interesting issue, but I'm getting off the track. There is no genocide imputations in the special jurisdiction for peace, even though there could be, which means that there is a very ardent discourse on whether environmental damage per se.
Forgive me, Federica, you're not answering my question.
Sorry, can you restate your question then?
But the question is, what is the precise relevance of the Polish forest cases in international law today?
I think it gives precedent to the prosecution of environmental damage as a legal good and as a war crime or as a crime against humanity to the current matter of international criminal law.
Bingo.
Fair enough.
Yeah, sorry about that.
Many thanks to all speakers for your presentations. My comment and question also goes to Federico. Thank you for this comprehensive analysis of charges you have discussed and this contemporary context. I was wondering if you see any direct links for possible prosecution of environmental damage in Russia-Ukrainian war and charges that are being addressed today. But to your historical research, I will be very happy to assist you or help in searching sources. The Polish cases and are in the field of my expertise. I am Polish native speaker, so I will be happy to help you finding some broader context. Few publications from the wartime are even accessible online, where this first analysis and statements of facts concerning expropriation, also in the field of agriculture, destruction of forest and nature during the war that were compelled by the Polish government in exile, are accessible. So there was even one specific publication dedicated to the destruction of Polish forests from 1942. So that may be also helpful for you to go further in this research. Thank you.
Absolutely, and thank you so much for offering your help. I would love to get in touch because yes, I did see mention to that document, but I never saw it. I could never find it anywhere, which was a big disappointment. Regarding the matters of the Ukraine-Russian war, I'm not that aware of what cases have been made regarding environmental damage, so I really couldn't say. I know there has been damages towards, or there have been allegations towards the blowing of the Nowa Kakhovka, it's how it's pronounced, I'm not sure, dam, and the fact that it was it's a massive risk to place. I think it's interesting also to compare how the Ukrainian undercurrent perspectives. Ukraine also talks about the lack of distinction in the attacks, which is more classical international humanitarian law, and it absolutely seems to be true, especially in the blowing of dams, as well as the risk, for example, when talking about the Energodar nuclear plant. So I think it's interesting to see how this has developed to both actual environmental damage and the risk of environmental damage, which is, I think, very prescient for Eastern Europe and Ukraine specifically. But unfortunately, I'm not that informed on the specific charges pressed against Russia. So it would be very interesting to see. Thank you so much. And thank you for Amina for the email. I have your email, Dominika, so I'll get in touch with you.
So one more question to you, Federico and Claire. Federico, you have presented this case analysis. Did you find any or came across discussions when studying the protocols of Commission's meetings addressing this particular problems or set of crimes? And Claire, whether there were discussions concerning crime of slavery, like dedicated to classifying specific cases as slavery. I would be grateful for some thoughts on that.
So I'll answer very quickly because I think I'm taking up way too much time. I did not find those issues, I'm sorry to say, but I would absolutely like to continue delving on this issue. So if I find anything in the coming days, I'll let you know.
Oh, thank you. Apology, I haven't found anything which connects the practice of slave labour and the policy of slave labour to slavery as a discrete crime, beyond it being characterised as part of sort of the war crime of forced labour or the crime against humanity of slavery, but that hasn't come up terribly much in the War Crimes Commission reports so far that I've looked at. What I find really interesting is that certain jurisdictions focus on slavery more clearly, probably because of the weight of evidence that was before them. So, for example, I think a lot of the Belgian and French charge sheets don't refer greatly to slavery, but the example that I gave of Czechoslovakia, they speak greatly about it, and there's a great deal of focus there. So I need a lot more research, to do a lot more research in this area to find out what was said and how it happened. But it tends to be that they refer to the slave labour policy and then to say that there was ill treatment, but there doesn't tend to be a great deal of clarity there of what slavery is as a crime, unfortunately.
Thank you, Claire. I'm going to step in as chair for the rest of the session because Andrew has to leave to get a flight, so he's to go to the airport. So Chidi, did you have a question?
It's not so much of a question as it is an observation, really, and based on mostly to appreciate what Dan's done. I mean, you've done because from today's session alone, you observe that a lot of the international crimes being prosecuted as if they've just been newly prosecuted or identified as international crimes, such as slavery, environmental crimes, or gender crimes. From today, you could see that they had been prosecuted by the UNWCC, and later was none of these instances of such prosecutions, and they could have been prosecuted then as national crimes because of the emergence at the time, it is, or the nascency of international criminal justice at the time. And so if not for the work that's been done, so the archives, Dan's work, and sessions like this, these things will remain hidden. And so it's good for us to continue this sort of work, and then eventually it gets wider audience, and then it gets appreciated what the work that the Commission had done, and then the connection will now get stronger to contemporary international criminal justice. Thanks.
Thank you, Chidi. I fundamentally agree with everything you said. Do we have any more questions or comments, either online or in person?
Yeah, it's something that just occurred to me now. To Dawn, I don't know if you came across. There's a widespread idea today that aggression is a leadership crime. So that means that soldiers who receive orders to commit aggression are not internationally, criminally liable for the crime of aggression. I believe that that's not in tune with how the question was viewed by the Nuremberg judgment and the MITEF, the Far East Tribunal judgment. Did you come across us with any issue of superior orders in relation to aggression?
No, mainly because it just wasn't something that was being considered, given the offences that the trials were specifically looking at. It was much more kind of a much lower level than the central decision around waging a war. I mean, that very much, I think, I mean, my understanding is that's very much something that was looked at by the international military tribunals, because it was those in at that level who were responsible for the conspiracy and the planning and the waging of the war. Definitely, in terms of the Australian trials I looked at, it was people actioning the war rather than kind of entering into the war in the first place. So it was a completely different kind of level of kind of officers that were being examined.
I just asked this question because the Australian judge in the Far East Tribunal expressly said that it was not a leadership crime, that anyone could commit a crime, and there was no allegation of superior orders. That's why.
Yeah, he's an interesting character. He made some observations about because there was some controversy over whether he could take up the role in the Far East Tribunal, partly because he'd been so involved in the preparation for the domestic trials, and they had to make some very clear statements about his involvement was essentially a Chinese wall between what he'd been doing and then what he was going to do in the Far East. But no, I didn't come across anything.
Thank you.
Just to, as I've got the microphone, as it were, the proverbial one, on Ethiopia and documents around the prosecutions, not the UNWCC specifically, but if you're looking for peripheral documents, is there anything that's in Sylvia Pankhurst's journalistic output? Because I think that she was writing a lot in relation to Ethiopia around that time, and I wonder whether there was anything in her writings that might supplement the legal document, shall we say, or the political documents.
Yeah, the Pankhurst is one of the key secondary sources that we had to rely on to gain insight to what happened in Ethiopia. So yeah, you're right. Thank you.
Thank you. Are there any other questions or comments for our panelists? Okay, on that note, I'll bring the session and the workshop to a close. I'd like to just begin by thanking Dawn, Claire and Federico for joining us remotely, and also for Chidi, who was able to travel to Maynooth today to be here. So thank you very much to all of you for your wonderful presentations.
Thanks to you, Amina.
Oh, thank you. So just to wrap up, guys, just to express my gratitude to all the people who made this happen. So our keynote guests, Dan, Andrew, who is no longer with us, Dominika, those who participated remotely today, Dawn, Claire, Federico, and Stefan. Those who were here, Chidi and Miguel, and those who joined as well. Thank you so much for joining us here today. I think we've had a really fruitful day of rich discussion. There's many themes that have come out of today. And I guess in terms of next steps, it would be great if we could kind of I don't know, keep this going in some way, you know, maybe hold a similar event somewhere else next time, and hopefully get to meet some of you guys in person as well who joined us remotely today. This is something that in the past about 3 to 4 years, this is about the 3rd event I've organised on the UN War Crimes Commission that we've done either online or in person or hybrid. And there definitely is a very rich base of scholars who are working on these issues, and it looks like we're all doing different things, but there's overlap. So it's great if we can kind of come together every now and then to share our ideas and flesh things out a bit more. So I'll be in touch with you going forward in terms of maybe having conversations about what we can do going forward. And before we wrap up, I'd also like to thank the funders again. So the Maynooth University Social Sciences Institute and the School of Law and Criminology here in Maynooth as well. I'd like to thank Anne Hamilton-Black, who's been doing a wonderful job all day of managing all the AV and the Zoom and everything. So thanks so much, Anne, for that. And also to Stacey Campbell of the School of Law, who organised a lot of the background stuff as well. I know she's not here in person, but just to acknowledge that. So that concludes our workshop today. Thank you to everybody for all your wonderful contributions, and I wish you all the best with your work going forward.